for disposal of that application.
On order was there, I think, at the
Yes.
time of admission of the appeal.
Yes.
Then why for
The
the
application is pending, application is required to be disposed of, so that my lord appeal may be proceeded with.
you are for the appellant?
I am for that.
Served.
Yes, my lord, notice serving.
Lordship, may I to leave to mention one motion? This appearance
Application heading tell.
Yes, motion.
motion, this state motion.
Item number.
Item number no, madam, it's new motion. Matter was moved, but your lordship during course of hearing, some document was not annexed in the writ petition. Your lordship given liberty to file supplementary affidavit. I prepare supplementary affidavit. Let the matter be appear in the list.
Okay.
My
Motion.
lord, one
Lord,
my lord,
another
not
matter-
prosecution. My lord, I do not want to proceed with the appeal.
Kindly, I am mentioning your application for substitution after setting aside of abandonment. And
Lordship, another matter, item
Have
number.
you served it?
Lordship, first of all, section 5 will be allowed. If allowed, then my lord, I will serve the copy.
Section 5 application has to be served.
My lord, such application for substitution, my lord, I have not served, my lord. First of all, my lord, substitution, setting aside of abandonment will be allowed. Then, my lord, section
Then
5.
you serve the section 5.
Section
All
5
applications has to be served.
section 5 তো আপনাকে
কাকে
সাবমিট
service
করব
করতে
না না আদার সাইড তো আছে আপনার কেউ
You have to serve other side, otherwise it
section
is
5
not
তো
eligible.
মানে another matter মানে item number 24 kindly make it not today matter
Item number.
24 matter.
Okay.
Lordship, may I be permitted to mention one application for upgradation, Lordship? Earlier, the stay was granted and it has expired, Lordship. And in the lower court, Lordship, first week of February has been fixed for execution. Lordship may kindly fix it for upgraded. As
What
an
matter?
Lordship is the second appeal, Lordship. It has been admitted and the question of law has been framed, Lordship. I'm only
Substantial question of law has been framed.
already been.
So one order is there, I think, for the stay.
Yes, your Lordship, it has expired, Lordship. I'm only paying for an extension. That's why it is running in the list. Lordship may kindly make it for as an upgraded application, Lordship.
Upgraded application. Whether it is running in the list.
Yes, Lordship.
What is the number? What is the number?
Number
List number? Monthly list number. It will be appear in the list, monthly list.
item. Yes, sir. Friday, Lordship.
It will be appear on Friday, no issue. You mention on Friday.
Lordship, on the last Friday, it was mentioned before your Lordship also at the time of rising, and Lordship was pleased to direct to mention it today.
May I be permitted to mention, my lord, extension of interim order. Interim order going to expire on Friday, my lord.
Interim
Group
order.
8. Group 8 matter, my lord.
Group 8 matter.
Group 8.
My lord, may I be permitted to mention, my lord, at the time of admission, it is a categorical order of the division bench that the impugned degree would be abide by the result of the appeal. So, my lord, there is a stay. Though there is a stay, the executing court proceeded with the execution, and the 31st was the date fixed for police help for granting executing
Now,
process.
you know the in every second appeal, at the time of admission of second appeal, this is the regular order that the executing court may proceed with the execution proceeding, but so far as the framing of final decree is concerned, that cannot be done.
That cannot be done, but my lord, the learned court below, the executing court now want to proceed with the execution proceeding by final execution. My lord, this matter has previously appeared before my lord Justice Vivek Chaudhary as his lordship then was.
Is it partition suit?
My lord, it is a suit for declaration, and now it is partition because a part has been-
Partition means the preliminary
It is
decree is
suit for
there.
declaration. It is a suit for declaration. Against that, in lower court, in the suit court, suit was dismissed. I'm the defendant.
No.
In the appeal court,
Is there is an order of the division bench that the execution would be subject to the order of the second
my
appeal,
lord, my lord,
then what is the difficulty to proceed with the execution proceeding?
my lord,
Why would not apprise before the division bench that I want a stay?
kindly consider what is the order in the division bench. The impugned degree, my lord, not that order. Impugned degree would be abide by the result of the appeal because, my lord,
That's why the execution has not stalled.
my lord, during the pendency of the appeal, government has acquired the property and patta has been submitted. A portion of the property has been patta to defendants. That's after considering this order has been passed. My lord, kindly once my lord kindly take this matter, my lord will go through all the
If the authority has issued the order of patta in respect of other persons, then you can challenge the order according to the law, not before the appellate
My lord,
court.
but authority is not giving any order. Now the executing court.
Executive court cannot issue patta like that.
Executing court directing the police authority to transfer the possession to the plaintiff.
I cannot understand.
After the patta
You
has
have
been
not,
granted.
you have not prayed for the stay of the decree, stay of the
My lord,
execution before the before
prayed.
the division bench.
My lord, I have also prayed the same. My lord, that application is pending.
The order was passed in that application.
On that, this order was passed.
Then the matter was disposed of. How
Application
just,
is,
how
Malad,
this single bench can
that's
set
why
aside the
I have
order of the
filed
division bench?
another application. That's why nowadays
What application you have filed?
my lord, CAN number 2605/2020.
Have you served?
My lord, already served. They have also appeared. First time after appearance, the learned advocate appearing for the opposite party, they submit that no objection has been. I have given the no objection Vokalatnama to the opposite party. Then, my lord, this honorable court direct me to serve the copy upon the learned lower court advocate. I have also served them. They have also received the same, and they have appeared. When they have appeared, they prayed for time, and now this matter is pending.
What about, so what you want? The application?
Application.
Have you served the application, the mentioning matter? Before mentioning, you have to serve. Before
My lord,
mentioning,
My lord, no advocate is appearing in this court in this matter. So, my lord, where I should
whatever,
start?
if the matter appears, I again direct you to serve upon the
My
party
lord, then it should
Okay.
happen. my lord.
My lord, I mentioned,
under the application.
my lord, I mentioned, my lord, it is second appeal, it is ready for hearing, my lord.
Second appeal for the year?
My lord, 96 and 2008 and 2014, my lord.
I have the long list of second appeal.
My lord,
I cannot dispose of those appeals.
It was earlier in one bench, my lord, but the due
What
to
is the
change of-
purpose for
a
listing?
change of determination.
What is the purpose for listing? Let some matter be disposed of, otherwise the list would be.
My client is regularly, my lord, very much annoyed, my lord. Lordship, kindly list.
Lordship, may I be permitted to mention one MSCC matter, not for
Okay.
modification?
Yes, MSC matter for what?
Modification matter, Lordship has directed us to deposit the awarded sum before the learned tribunal. But inadvertently, we have deposited the awarded sum before these honorable court, I mean, before the learned institution. Therefore, we shall be praying before the Lordship that liberty may be granted to
Withdraw.
the claimant to withdraw the same from this, from the learned registered judge.
So you want some modification in the order?
Yes. Lordship.
Do you mention?
My lord, may I be
Yeah,
permitted
yeah,
to
yeah.
mention a second?
Your lordship, leave to mention one second appeal, my lord. With intimation to the other side, because I do not know who is appearing as a lawyer. I intimated the party directly by speed post, and they have already received the said
What
And-
else? Hearing of second appeal?
second appeal. My
I have a long list of
my
hearing.
lord,
I
only
cannot.
one thing,
What is the year? What is the year?
it is of 2009,
2009.
and the matter is a money claim.
Okay.
Nothing.
You are the appellant.
I am for the respondent.
Respondent. Who is for the appellant?
Appellant, that is why I have some copy of the appellant.
Okay.
The clear case is that the wife is the appellant and husband is the respondent along with myself.
Along with?
My name is going to the respondent, number one, and his husband. The appellant's husband is the respondent number two.
Okay. Take it.
My lord, may
My lord,
Yes.
Upon notice,
Yes.
My lord, may I be permitted to mention one second appeal? My lord, it has been already been mentioned before we prayed for your lordship. Everything is
That hearing second appeal. Year?
Here is 2017.
Well, hearing matter, 2007.
Hearing matter.
2007.
my lord. Kindly, my lord.
I can list it, but I do not know
Kindly
whether
list
matter
the
can.
matter.
Some old matters. No, no, no. Some old matters are there. What is the purpose of listing?
My lord, already.
If I list this matter, the list will appear 77, 87, 88. They are old matters. I have to dispose of those matters first.
My lord, kindly listed the matter.
What year?
2007, my lord.
Okay.
My lord, 2013 matter, my lord,
Upon notice.
Admitted.
Application.
Application.
my lord, 2013 matter, second appeal paperwork. has
No,
been-
no, no, no.
My lord, kindly list in
No,
the matter.
Before 2010, I can take up. After 2010, I will not take up. Okay.
My lord,
Let some matter be disposed of. Otherwise, the list would be in.
My lord, may I permitted to mention one matter? And mentioning a matter praying for an application to be listed, application for restoration, which has been filed in the year 2024 itself. The matter has been
Application for restoration in connection with second appeal.
second appeal, my lord.
Have you served?
Yes, my lord, upon notice.
My lord, maybe point to mention listed item, item number 61, my lord. Last 61, hearing matter. First item, my lord. Narayan Chandra Garai,
First matter.
first matter, my lord. Last Wednesday, I mentioned it and prayed for 2 weeks adjournment. Your lordship was pleased to grant me the adjournment, but it is has appear on the list. I am praying for not this week on this ground, my lord. Challenging the order of
You are for the
read
petitioner.
petitioner, my lord. Challenging the order of addition party have filed the appeal, and appeal is running in the list of their lordship presiding over Rajasekhar Mansa, my lord.
Very well. Okay.
May be permitted to
Not this
mention,
week, my lord. Not this.
permitted to mention one matter, your lordship, item number 81, if your lordship's list, your lordship. The matter is ready for hearing, your lordship, all the affidavit.
I will take up the hearing. What is the purpose of mentioning? Why you mention this matter?
Your lordship, the impugned order passed by your lordship has been passed in the month of November, your lordship.
Expired.
Yes, your lordship.
Interim order expired.
No,
Then
it's not expired, but the matter is not coming in. The matter is not being heard for a long time, and the ration shop. It's about a dispute about a ration shop. It's being closed
it's a
for.
matter of 2024.
Yes, your lordship.
Then
Your lordship, the returnable date of the matter was in the month of November, your lordship, and then from then the matter was is appearing in the list, but it's not being heard. So, if your lordship can you fix one date for the hearing of the
No,
matter.
no date can be fixed. Let it be done in the list. I will take up the matter.
My lord, may I be permitted to mention one matter, my lord? It will take only 5 minutes, my lord. It is for a general order regarding ration shop in notification of vacancy in my area, my lord. It will take only 5 minutes, my lord.
What is the number of the list?
It's supposed to be in the list, today's list, but it was not in the list, my lord.
Then you mention it. What is the number? Give me
1774 of
the slip.
2020.
Give me one person to give me the slip.
My lord, I have mentioned it. My lord, I have mentioned
No,
it.
online mentioning is not necessary. I want the slip.
Okay, my lord. Okay, my lord. Obliged, my lord.
Call the list.
Lordship, I appeal on behalf of the petitioner in item number 1.
Item number 1, Mrs. Blue Star Limited.
Yes, Your Lordship. And on the respondent in item number 2.
CRR 3944.
Yes, Your Lordship.
I am reading out the only operative portion. Considering the entire circumstances, according to the view of the Honorable Supreme Court, as discussed above, I am of view that mere proceeding of the criminal complaint being complaint case number CS 63855 of 2016 pending before the London Metropolitan Magistrate Third Court, Calcutta under section 415, 418, 420 of IPC. If allowed to be continued, it would be sheer abuse of process of court. At this juncture, I think it necessary to invoke my inherent power, invoke the inherent power of this court to quash the criminal process. Accordingly, the instant CRR being meritorious is allowed on contest. The criminal proceeding being complaint case number CS such and such pending before the learned Third Court of Metropolitan Magistrate, Calcutta against the present petitioners are hereby quashed.
Grateful, Your Lordship.
Next, item number 2.
Yes, Your Lordship. This is, we are for the respondent.
CRR 2499. Messrs. Boo Ice Construction.
Yes, Your Lordship.
Considering the entire aspect, I find no reason to interfere with the proceeding pending with the London Magistrate. Under the above observation, the instant CRR appears to me devoid of merit and the same is dismissed.
Grateful, Your
CRR
Lordship.
disposed of.
Great.
Any order of stay passed by this court during the pendency of the instant CRR is hereby also vacated.
Much of it.
Call the list.
Well, in this matter, I am for the petitioner. I am praying 1 week time because on last Friday, the state served me a copy of the report. I want to use an exception against that report. Kindly keep it on next Monday. Man.
No, I cannot maintain it in the list. You mention it.
Lordship, last Friday,
Okay.
I got the report. Just I praying 7 days time to file them a reply. Will again, my lord, I have to. Lordship.
Mention. List is very long. That's why okay. Learned counsel appearing on behalf of the petitioner submits that the exception is not ready. Concerning the submission, the matter is.
For the supplementary affidavit filed by the state, man.
Exception. Exception
Against a supplementary.
to the supplementary affidavit filed by the state is not ready.
Grateful, man.
Full stop. Let the matter go out of list. Parties are liberty made.
Grateful, man.
Next.
I am for the But this is a case where there are 3 petitioners. Filed the writ petition.
For the state response.
3 petitioners filed the writ petition in representative capacity for non-payment of additional commission as provided by the central government. If you want to kindly see the order passed by Justice Portonayo on 20th May 2024, sorry. May I hand over the copy, ma'am?
20th May.
Well, kindly turn the inner page 5 of the order.
Now, what is the issue?
Issue is, my lord, state is not providing additional commission
Additional.
to the
commission.
fair price shop dealers
Okay.
for performing e-post machine at delivery point. Central government providing the money, we have shown to it. Kindly come to my lord, inner page 5 of the order. Second paragraph.
Yes.
The prayer for leave to move the writ petition on the representative capacity under Order 1, Rule 8 of the Code of Rule 12 of the Appellate Side Rules is taken up for consideration at the threshold. Then you will also kindly turn the page. Page 6, second paragraph, last line. Page 6, second paragraph, last line. Prayer for leave in respect of the aforesaid stands rejected. Have you also got my lord? Page 6,
Prayer for
second
leave
paragraph,
in
last 2 lines. Accordingly, prayer for leave in respect of the aforesaid stands rejected. So leave to move the writ petition through representative capacity has been rejected. And direction has been given for filing affidavit. You will also kindly run the last page of the order, page 8, last but one paragraph. The state respondent are directed to file affidavit in opposition to the petition within 1 week on reopening of the court after the ensuing summer vacation. Advance copy of the affidavit in opposition be served upon the learned advocate for the petitioner. Reply thereto so and so. But this is an order of 20th May 2024. But so far the rejection part is concerned, we preferred an appeal before the Honorable Division Bench. If you will kindly see the order.
I've got the order.
Well, kindly see page 7.
MAT 1126.
My lord.
Page 7.
Page 7. Issue has been considered. Paragraph 15. Under such circumstances, we are of the view that finding of the Honorable Single Bench with regard to absence of commonality interest in the matter is unsustainable, and the order to the extent it declines permission to applicant so and so to institute the proceedings in representative capacity is set aside. Honorable Single Bench shall permit the applicant to institute the proceedings in representative capacity. So, this part has been quashed and set aside. Then direction has been given for hearing of the matter by the Single Bench.
Yes.
Well, this matter again appeared before your Lordship. Kindly see the order. Dated, my lord. Last order passed by your Lordship November. 4th November. As the last chance, my lord, direction has been given for filing affidavit. 4th November. Within 30th November. Third paragraph, order dated 4th November.
Yes.
Okay, this is the issue.
My lord. So till today, no opposition has been filed. We are not getting the additional commission. Almost the division bench held that this commission is being provided by the central government. It is our entitlement to get the same. If you will also kindly go through the division bench judgment, it has almost held. Kindly once again take up the division bench order. Page 4. Page 5, paragraph 6, 7, kindly read, my lord. To ensure smooth and exact supply of food grains to entitled persons from fair price shops, point of sale device to be installed and operated at fair price shops. In order to incentive this profile, Rule 7 of the Rule 2015 provided additional margin of ₹17 per quintal, subsequently enhanced to ₹25 per quintal to the fair price shop dealers towards cost of purchase, operation, and maintenance of the point of sale device, its running expenses. It is the grievance of the petitioners, neither the appellant, petitioner, nor other fair price shop dealers throughout the state of West Bengal are receiving the proportionate additional margin for the use of point of sale device at the fair price shops. Accordingly, the appellants, petitioners approached this court. Honorable Single Judge so and so affected the connected respondents authorities. So the Honorable Single Judge declined. In light of the nature of dispute, this court directs the respondent authorities to submit an affidavit whether the fair price shop owners are receiving the additional margin under so and so. Paragraph 12. Affidavit is placed on record. In the affidavit, it is entirely stated as per Rule 7(6) subclause B. The state government has selected a system integrated for purchase, installation, and maintenance for point of sale device at an amount of ₹12 per quintal, which ought to be deducted from the additional margin emphasized under the said rule. However, there is no averment in the affidavit whether even the reduced margin has been disbursed to the fair price shop owners or not. On the other hand, a wholly irrelevant plea that the dealers are receiving ₹25 per quintal under order so and so, dated so and so, for doorstep delivery of food grains has been annexed. The additional margin for doorstep delivery is independent on the right to dealers to claim additional margin for point of sale device under Rule 2015. Accordingly, we are of the considered view that the materials on record show that the appellants have emphasized a grievance of non-grant of additional margin under Rule so and so fair price shop owners, in which all of them have communally interested in pair so and so. So, an affidavit has been filed before the division bench. State failed to prove that this margin, which is being provided by the central government, is being disbursed to the fair price shop dealers.
Okay.
These are the position.
Firstly, my lord, I was on standing here, I cannot improve on records. There is no affidavit has been filed, as my learned friend has pointed out. Today, the matter is appearing as to be mentioned. Lordship perhaps will not hear out the matter. I would humbly beseech your Lordship to grant me the shortest possible time to file my affidavit in opposition, so the matter can be heard out. But firstly, there
No,
is
you
also
take a decision at least on that point so that I can dispose of the matter today. The matter has to be, what is the purpose? You have to take
matter
a
perhaps
decision.
perhaps has to be heard out. I mean, to be mentioned, perhaps not. I am not put on notice.
No, I understand. It's
Also, Malad, there is also another issue. That I'll join and Malad, I'll differ from my respectfully differ my learned senior friend on two counts. Firstly, if your lordship sees the order of 20th May 2024 passed by Justice Pattanayak, my learned friend's contention that he had a commonality of cause of action was not considered by the honorable judge. Challenging that and challenging the refusal of the ad interim order, my learned friend went up before the appellate court. Now, what my learned friend did not, but perhaps I'm going to say did not show, kindly comes to paragraph 15 at page 7 of the order of the appellate court presided by Justice Bagchi.
paragraph 15.
Paragraph 15.
Yes.
Well, it is not that the leave has been allowed by the appellate court. Appellate court found force in my learned friend's contention that there was a commonality of cause of action,
That
which
is altogether separate issue was
yes, but no,
decided by the-
Mala, kindly hears me.
Yes.
Not more than 2 minutes on this point. Mala, what the appellate court said was my learned friend has a commonality of cause of action, which is sine qua non for invoking any provisions of under Order 1, Rule 8. But kindly read paragraph 15 just for my satisfaction. Under the circumstances, we are of the view the findings of the honorable single judge with regard to absence of commonality, it should be commonality of interest in the matter is unsustainable, and the order to the extent it kindly notes this, to the extent it declines the permission to petitioners to institute the proceedings in representative capacity is set aside. However, the single bench shall permit the appellant writ petitioners to institute the proceedings in representative capacity as per law. So, as per law would mean, your lordship is aware under Order 1, Rule 8 has several parts. First, the litigant has to satisfy there is commonality of interest, which my learned friend has satisfied. The appellate court, pursuant the order was passed. Now, having established his commonality of interest, he ought to follow the procedure prescribed under Order 1, Rule 8, which is publication of the notice. Notice subject to correction till date has not been made. My learned friend is espousing the cause of perhaps all the concerned dealers. In the absence of a notice, your lordship is aware, notice under Order 1, Rule 8 is mandatory. In the absence of a notice, perhaps this writ petition cannot proceed at this juncture. That is the first objection. When Order 1, Rule 8, if I may place, I'm not carrying the book, if your lordship would have a copy of the Code of Civil Procedure. But there are layers to Order 1, Rule 8. The procedure has to be followed. Even the division bench has held the same.
Blue wood. Only Yes.
And this is Order 1, Rule 8. One person may sue or defend on behalf of all in same interest, where there are numerous persons having same interest in one suit. One or more such person may, with the permission of the court, sue or be sued, or may defend such suit on behalf of or in benefit of all persons so interested. This stage perhaps is over in view of the order of the division bench. Then perhaps B has to be complied with. The court may direct that one or more such persons may sue or be sued or may defend such suit on behalf of or for the benefit of all persons so interested. Now kindly come, this is where I say this stage has to be complied with. The court shall in every case where a permission or direction is given under sub-rule 1. So if I also take it that a permission has been granted pursuant to the order of the Honorable Division Bench, at the plaintiff's expense, give notice of the institution of the suit to all persons so interested, either by personal service or by reason of the number of persons or any other cause such service is not reasonably practicable, by public advertisement as the court in such case may direct. So, this has to be complied with in my respectful submission.
Yes.
Without compliance of Order 1, Rule 8, Sub-Rule 2, this writ petition cannot proceed. Your lordship so desires, my lord, gives me one day, I'll come back with judgments which says that this compliance of Order 1, Rule 8, 2 is mandatory. Rule 8 sub rule 2. This has not been done till date. And the Honorable Division Bench, your Lordship would see, the Honorable Division Bench says in paragraph 15, has categorically held Honorable Single Bench, at the risk of sound repetitive, shall permit the appellant writ petitioner to institute the proceeding in representative capacity as per law. So that would mean Order 1, Rule 8 sub rule 2 has to be complied.
I understand your son. So you are submitting that the said
The
formality
publication has to be made.
without permutation, the
Yes,
matter
he has
cannot
to
be
make the
proceeded further.
publication.
Yes,
And
Mr.
the other
Sagar.
can on merits, your Lordship would
I'm
grant
not
me.
standing on the.
Then on merits, your Lordship would grant me some time, maybe a week's time to file my affidavit. But the matter can be heard out. It's appearing as to be mentioned. I'm led by Mr. Shuman Sengupta. My lord. I mean, we could not sit together for a conference.
Okay.
Well, I'm accepting the submission made by my learned friend. If court directs, definitely we have to do it. But without court's order, we cannot do it.
No.
Yes,
Because the court
has
directs,
to
the division bench directs, the learned single judge shall allow the writ petitioner to proceed in accordance with law. So if court directs, we have to do it.
Okay. I am directing today.
Fine.
You just proceed with the service of notice.
And they should file their opposition within a certain time.
Okay.
Let the matter be.
Please take down.
No, my lord, service of notice, not the publication in the newspaper.
Publication.
What newspaper? Bengali newspaper.
In terms of the direction of the Honorable Division Bench in MAT 1126 of 2024, the petitioner is directed to proceed the instant matter in representative capacity. Full stop. In such a way, the petitioner is further directed to comply the provision under Order 8, Rule 1 within bracket 2 of the CPC by making a publication, making a paper publication in Bengali daily newspaper. Paper publication in a Bengali daily newspaper, well circulated throughout the state of West Bengal. Full stop. Before publication, the draft has to be placed before the concerned department, so that the draft.
Department.
Yes.
It's not the issue before the department possibly, my lord. We shall publish it for the dealers.
There is
They are the
perhaps
necessary for checking the
approval of it.
approval is.
No.
No.
The order has to be passed by the court. That's the requirement.
In Delhi newspaper, that's okay. Within 7 days.
The publication has to be made within a fortnight.
My lord, I'm led by Mr. Chen.
This is all right.
Within a fortnight. Let the matter appear in the list.
In the meantime, they will file their
Yes. And let the
10
matter
days.
appear in the list.
10 days, 3 days, matter to appear in particular.
Let the matter appear in the list on 18th of February.
But can it be fixed at any time? Because very small point is involved. At 2 p.m., 3 p.m., at any time.
No, 10 days and 1 week would be appear after 3rd
10
week.
days and 3 days. I am paying for 3 days.
10 days means the working 10 days will be appear after 3 days. That means February 2nd week would be gone.
My lord. Any day, particular time.
Come on 17th then.
February.
17th
17th February.
17th February. Full stop.
At 2 p.m.
In the meantime, at 2 p.m.
My lord.
Why 2 p.m.?
Let it be hard, my lord. Otherwise, there are so many hearings. Because this is a hearing matter.
I do not know. There are 7 matters. 17. In the meantime, the state authority directed to submit the affidavit in opposition within 10 days. Reply if any, but no, not fixed. Okay. Reply if any by the petitioner within 3 days thereafter. Let the matter appear in the list on 17th of February at 2 p.m.
Or can it be treated as hard in part matter? You will also heard this matter twice.
No, not
As
necessary.
well, as well.
Not necessary.
As well. At 2 p.m.
Okay.
Great.
Next.
My lord, there is a typographical error in the order, my lord. In first page, the repetition year of the repetition should be 2024.
Yes,
And in page number 4, last but second para, the impugned order date should be 6 December, my lord.
not
instead of-
16.
No, my lord.
Okay. Please take down. This matter appears for correction. Full stop. Next para. In order dated 21st of January 2025, the writ petition number was erroneously written as now writ petition number should be correctly read as 30552
Of 2024.
2024
24. Yes, sir.
instead of 30552 of 20234. Full stop. Next para. In paragraph 4, sorry, in page 4,
In page number 4, my lord.
in page number 4, at paragraph
but
number,
second.
last but second paragraph,
Yes, ma'am.
last but second paragraph, the date of impugned order
Should be 6.
should be read as 6th of December instead of 16th of December. Remaining portion, the order shall remain unaltered. Next.
I'm filing my affidavit in opposition.
Lordship, I'm for the petitioner.
Yes.
Lordship, there is an affidavit of opposition. We wish to file a affidavit in reply, Lordship. I'm led by learned advocate Mr. Prosenjit Mukherjee.
A report in the form of affidavit filed on behalf of the respondent number 5 is taken on record. Full stop. Next para. Petitioner intends to use reply against the report. Let the reply be filed within 2 weeks. Full stop. Let the matter go out of the list. Parties are liberty to mention.
Grateful, madam.
Just wait. Yes, item number 7.
Item
I have passed the order.
within 7 weeks, 7 days. 2 weeks.
Within 2 weeks.
But actually, the online portal was showing item number 5. It's standing right outside.
Item number 7 is there.
Yes, yes, on the board.
Okay.
But not on the online.
Online portal is not running so fast. Okay. Okay, come on after 2 weeks. I'll hear the.
Your Lordship, I appear before the state, Your Lordship. Your Lordship, this is that matter where the petitioner had undertaken to withdraw because of the false statements made in the petition, where the license has already expired, yet they are claiming to be the license holder. The petitioner on the last occasion took adjournment to bring in the written instruction, so to withdraw the matter.
Yes.
Since thereafter they are taking time.
This
Your
matter, Lordship, upon instruction, Lordship, and Lordship, liberty given to file a fresh, Lordship.
Lordship, the matter is instructed and liberty. Your Lordship, there is nothing left in this matter.
Let it
He doesn't
let them
have the existing license.
However, the matter is not hard on merit. Let them given a liberty. You are appearing. What is your name?
My name is Sababuddin Lashkar, Lordship.
Huh?
Sababuddin Lashkar, Lordship.
Sababuddin Lashkar.
Yes, Lordship.
You are the advocate on record.
Yes, Lordship.
Mr. Sababuddin Lashkar.
Yes, Lordship.
Learned counsel. Mr. Sababuddin Lashkar, learned counsel, appearing on behalf of the petitioner, submits on instruction that petitioner is not intending to proceed further with this matter. Petitioner is not intends to proceed further with this matter. Full stop. State is represented by learned counsel, Ms. Asmita Chakraborty. Full stop. Concerning the submission of the learned advocate on record on instruction, comma, let the instant read petition be disposed of as not pressed with a liberty to sue afresh on the same cause of action. Next.
9, Your Lordship, I approve of the petition. It's a state, Your Lordship.
Speak for short Passover, Lordship.
Passover?
Your Lordship, then kindly makes it a not today, Your Lordship.
Come on, not today. Tomorrow I shall take up the matter. Okay. Very well. Not today.
Will I appear for the petition?
Yes.
Your Lordship, kindly take your Lordship's order dated 3rd December. Recollect, there was no proceeding initiated under clause 24, then the terminations made, a preferred appeal. In fact, the termination was at the directions of the second appellate authority. Those are the challenges, and Your Lordship, prima facie was satisfied and passed an interim order and directed for filing of affidavit. But they have not yet filed any affidavit. Now I am suffering the termination.
Yes. Have you, Mr. Chatterjee?
Lordship, kindly give some more time.
Again, some more time.
Because
it's the order of December 3rd. December 3rd. Today we have nearly crossed the 2 months.
Only in that case, my lord, I will be, my lord, renewing my prayer for stay of termination.
because my lordship was
Because I am suffering. I am without business. I had shown that I had the fixed deposit of 6,50,000. They had cancelled it on its whole count.
Lordship direction and already the card has been detached from this petition. That was on March, my lord, 2020.
It is temporary. It is always temporary.
That was
Unless new vacant, my lord,
Lordship was
new
giving
dealer
the
has been appointed.
order, but in spite of giving the order, my lord, because his challenge in March, order was passed on March and Lordship was, the matter was heard on October, my lord.
No. I challenge the last appellate authority's order. My lord, that is in November. That is in
Page 44, 5th of August.
Yes, Mr. Chatterjee, tell me when you can come.
It was communicated on
Kindly 10
23rd
days time,
September.
Friday.
10 days time, Lordship, kindly admit.
10, I cannot take you. Next week. Come on Monday.
Instead of Monday.
On or before Monday.
Lordship, kindly keep it a Tuesday, man.
Very well. I can, okay. Last chance, okay?
Lordship.
On submission of the Mr. Amritulal Chatterjee, submission of Mr. Learned Counsel appearing on behalf of the state authority, the matter be adjourned today. Full stop. The state authority is directed to submit the affidavit in opposition. To submit the affidavit in opposition or report. Affidavit in opposition. Affidavit in opposition as directed earlier by this court. On or before. On or before. Today is 7th, Monday. On or before 5th of February. Let the matter appear in the list on 5th of February.
As last chance.
As a last chance.
Third to fourth shooting, my lord, instead of third and fourth, my lord, there's on holiday, my lord.
That's why I'm fixing the 5th.
Because Monday, because you should affirm it, my lord. Lord, you kindly bear on 1 day, my lord, then. Because third and fourth, my lord, on the holiday. Keep it on 5th.
Wednesday.
2 days are 2 days are holiday.
Then third and fourth, my lord, is
So you can prepare it on 5th.
Yes, kindly, my lord, fix it on 3rd. If we find that any
3rd is the holiday.
No, 3rd, sorry, 10th. Monday.
If my lord,
Okay,
keep it on 10th.
Then if we find any reply is needed, we will be filing it by that time.
Okay.
Let them,
I fix the date on 10.
In advance, I'll serve in advance.
Yes. কি বললাম? বলো আগের প্যারাটা বলো। হ্যাঁ 10 10th of positive.
Grateful, my lord.
Positive.
Advance copy.
they will be serving
Yes,
us
yes,
an
sir.
advance.
Advance. Right. Grateful, man.
Not this week, not today.
For the petition, Lordship, can you make it not today?
Not today.
Not today.
Yes. Next.
On 13, I was praying before your lordship the matter be taken up on Wednesday. My advocate on record is seriously ill, my lord.
Very good.
Wednesday, my lord.
Day after tomorrow.
Great.
Next.
14 Lordship appear for the petitioner, my lord.
Yes.
Lordship would recall, my lord, it is that matter, my lord, wherein, my lord, the successful applicant, my lord, in whose favor, my lord, the license was granted, was found to be, my lord, a member of the Panchayat Samiti, my lord.
Yes.
But the state had taken time, my lord, on the last occasion, my lord, and I am told, my lord.
I am for the state. No, I can.
Lord, we've also pursued, my lord, we've also pursued, my lord, the BDO's office, my lord, and I'm told, my lord, that they have already issued a letter, my lord, stating that he was a Panchayat Samiti member. The state must be having that letter.
Item number 10.
14.
14. Item number 14. Yes. Which for the state authority?
My lord, I appeal.
What is your instruction?
My lord, a notice was issued on 21st of January, my lord. But it says that we sent a reminder, my lord, to the block development officer as well as to private respondents, my lord. But we are yet to receive any instruction according to the SCFS, my lord. But, my lord, my learned senior friend is informing this court, my lord, that notice was issued by BDO.
The BDO office told us, my lord, that we've already replied to the state's notice, but Mr. Singh is saying that they have not received it. I have no reasons to disbelieve that.
We were talking to the, we were having a conference with BDO only, my lord, when the matter was taken up. My lord, kindly pass it over, my lord. I'll inform your lordship. I'll directly
Okay,
talk.
pass it over. Pass over.
This is my application.
And for the private respondent, before my learned friend starts, I intend to raise one preliminary objection regarding maintainability of the repetition. I have already been selected, license has been granted to me. That is under challenge before your lordship.
Yes.
But your lordship will not find anything in the repetition or any document disclosing before the court that he is the eligible candidate. Not bank account, not any area, so far the shop room is concerned, no affidavit, land documents, not a single document, not a single pleading even, that he is the eligible candidate. Only he is challenging my license.
My lord, here.
Not even the area, location, size of the godown. I mean, just
My lord, your lordship kindly come to page 18.
not a single apartment and not single document. Let him prove first, my lord, that he is the eligible candidate.
Page 18.
18.
Notice.
Considering my eligibility.
No, it's a notice for
Notice for inquiry.
inquiry.
My lord, after being satisfied with the application and my credentials, the authority selected the persons for conducting inquiry. I was selected and my godown was inquiry was conducted on my godown. That is the fulfillment of eligibility. Now, my contention is this: the person who has been selected is ineligible because he is not qualified with regard to the godown. That's why I made a complaint before the authority. My prayer is very simple. My lord, let the authority decide the issue. Since he has been allotted, granted the license, the authority should decide with regard to my contention
and verify the eligibility of the private respondent, which I raised objection. That is my only prayer.
Yes, who is for the state?
Kindly see his complaint, my lord, page 20, my lord. What is his averment in this complaint? With due respect, I would like to draw your kind attention to that. I, Chandra Bibi, resident of village with some Baharampur district, Murshidabad, I applied for FPS in connection with the notification number, memo number, dated vacancy ID, application number. As my godown is inspected on 31st January 2024, but it was not inspected properly.
That's true.
In spite of having suitable infrastructure, my name was cancelled and an inquiry officer of SCFS officer has been given the FPS license to another person named Farida Batsa in exchange of money illegally, whose godown is 3 feet lower to the level of PWD road and there is no office attached to the godown. My lord,
These are the two grounds.
Lordship was aware because there's a procedure of inquiry, and after conducting thorough inquiry, that was sent to the expert committee, and there is a process, my lord. Lordship was very aware of this. Lordship, only for the averments, he has not created any locus to file this writ petition. First of all, he has to establish his locus. What is his minimum criteria he has maintained or not? Lordship was very much in this bench. Lordship was very much aware that the process given by this authority, there is an latitude, longitude, and that is scientific process was adopted by the Food and Supply Department. For the mere averments, we cannot dehouse this inquiry report, my lord.
Here, page 20.
And there is no challenge
there
at all. The inquiry report is bad in law, and there is no averment at the writ petition.
No, what is the matter? The person who is one of the applicant of a license
is competent, my lord. So far, my knowledge,
whether he can receive his report from the authority.
the report, my lord, regarding report is concerned, my lord, there is an RTI. Without RTI, we cannot supply the report.
So with RTI, the report
If,
can be.
my lord, if read for the RTI and you come with, we supply
There
the
is some
report.
provision to get the report.
Yes, my lord. There is no problem. He can urge for the application for the RTI. You can submit that.
Page 20, my lord, only two grounds. 3
No,
feet
I
lower.
understand you have some objections, but
Yes.
you have to demonstrate that you have a good
Yes, my
godown.
lord.
You have the all eligible.
No such
criteria
averment in the writ
there.
petition is there. No such averment.
Demonstrate before this court. Otherwise, how can
Only
I
come,
include?
everyone come and
He has
says
to
that
prove, my lord, his locus.
My lord,
He has relied on. Page 18
You
is
can
locus.
file the writ petition with your reports and everything.
everyone
report
come and
has
says
not been
government
supplied
officers
to me.
corrupted one, they can take
Have you
money.
applied
That is not the mere averment, my lord.
I have not applied for.
Then you
But
apply it for.
Let
You
them,
receive the report and file it again.
my lord, the state authority should say that I do not have the eligibility criteria.
That is not the
Eh,
procedure.
Let them come with the
No.
report.
Such type of allegations of every
Filing
person cannot
writ
come in the
petition, he
writ
cannot
court.
collect the evidence, my lord.
Yes, in the writ
Cannot. How he can collect the evidence?
My lord,
you have to demonstrate your case that you are such way eligible. You have a good go down.
He has some
You have
case.
a high go down. You have a spacious go down.
Bank balance.
Yes, everything is
Whatever
there.
criteria he has to
my lord,
fulfill this criteria.
That
all
you
the-
have not said.
all the documents is with me, your lordship. Your lordship, so desire I can file
My
supplementary.
lord, there is a
My
margin
lord,
system is there.
with
my
regard
What
to
is the purpose you file again? I can allow you if you file again. It would be better. Because they would raise again objection. By supplementary, you cannot submit.
well,
Yes.
objection has been raised to the authority. Let the authority decide it. Let them reject it.
No. That is not the issue. Issue is that if you before a read court, so you have to demonstrate your grounds so that I can proceed through your grounds, not the grounds of others, not the challenge of others. You file it afresh,
As your lordship.
having heard the learned counsel for the appeal, learned counsel for the parties, the writ petition is hereby disposed of as not pressed. Petitioner is at leave to sue afresh on the self-same cause of action. disposed of and not placed. Next.
Yes,
Yes, I appear on behalf of the state in this matter, Your Lordship.
May I file the affidavit of service, my lord? Lord, I have challenged, my lord, the license issued in respect of, my lord, in favor of, my lord, respondent number 6, my lord, on various grounds, which your lordship would find at paragraphs 14 and 15, my lord, my contention, my lord. That however, my lord, I should be, my lord, fair in my submission, my lord.
License was issued.
Yes, my lord, this perhaps, my lord, is not a case, my lord, where I would pray for, my lord, for an immediate, my lord, stay on the license, my lord. Lordship may give directions, my lord, for filing of report, my
What
lord.
is the ground for challenge?
Yes, lordship will find, my lord, paragraphs 14 and 15, my lord.
Yes.
Your Lordship,
Apart from that, my lord, most strikingly, my lord, my go down is 50 meters away from the vacancy spot, my lord, whereas, my lord, the go down of the private respondent, my lord, is about 2 kilometers away from the central
Your Lordship,
location,
the
my lord.
fact remains that that is not the only consideration point.
That is not.
Your
That is
Lordship, and the
Apart from
fact
that, my
also
lord, I have
remains
said
that upon inquiry, it has been found that the private respondent who has been awarded the license, Your Lordship, had scored much higher than the petitioner. Your Lordship, the area of go down of the petitioner is much
You
less.
come with the affidavit. You come with the affidavit.
With all the records, actually.
Okay.
Your Lordship, all the criterias, the size of the go down.
It is always the case. Otherwise, why will they give the license?
Yes,
But,
Your
my lord,
everything
at
is-
times we
and they have-
found, my lord, the licenses have been seen to have been cancelled, my lord. At times we found that.
Okay. Having heard the learned counsel for the parties, it appears that the incident petition cannot be disposed of without giving opportunity to the parties for exchange of affidavits. Accordingly, the state authority is directed to file a report in the form of affidavit within 3 weeks.
Yes.
Reply, if any, by the petitioner within 2 weeks thereafter. Full stop. Let the matter go out of the list, parties are liberty minutes. Affidavit of service filed on behalf of the petitioner is taken on record. Next.
Obliged.
Item 17, I'm praying for adjournment for today. Mr. Chakraborty is in this matter leading me. He's on his legs in court room 26.
I'm for the private respondent.
And for the
Private-
respondent number 7 years.
How many? You are the private respondent. You are also private.
We are the petrol pump owner at the partnership company.
But he is not ready today.
Tomorrow.
Tomorrow. Okay, very well. Come on, not today.
18 million, I am for the petitioner. This relates to conversion of license from proprietorship to partnership. But during the pendency of the writ petition, the proprietor died.
Proprietor died.
Yes.
So you want to withdraw?
Yes, because partnership has been formed. And thereafter, the petitioner challenged the same due to non-conversion of the same. My lord initially passed an order. In terms of that order, the authority concerned rejected the prayer of the petitioners. That is at page.
What is the prayer of the petitioner?
To set aside the impugned order. That is page 118.
118. 118 is the impugned order.
Yes, ma'am.
118. 118 টা দেখুন।
Rejection of prayer for changing the nature of FPS owned by Sri Satish Chandra Ghosh from proprietorship to partnership. They have rejected the prayer on the ground that as per new control act, control order came into force. But it was done prior to coming into force of the control order 2024.
তো অগাস্টে এসে গেছে।
So,
Because and therefore the cancellation was made on the basis of non-existence fact.
so now what happened? Satish Chandra died.
Yes.
Satish Chandra expired.
And three partners are still there. So naturally firm has been dissolved
Yes.
as per provision of the Partnership Act, unless and until it is reconstituted. So
So what can you do now?
He wants to maybe constitute new and then again.
Let it be withdrawn.
withdrawal matter become infructuous.
Yes.
Because withdraw is otherwise.
Yes.
Or liberty to file afresh after reconstitution.
No.
Why should this observation be there? You are always.
No, after because at
No,
present
you
partnership.
apply before the authority.
Yes.
Whatever you want,
Whatever you want.
apply before the authority. There may be a new cause of action.
Yes,
Okay.
everything is new.
Okay, please take down.
In a order is still exist. Impugned order is still exist.
No, impugned order in respect of Satish Chandra Ghosh. Satish Chandra Ghosh expired.
No. Satish Chandra, one of the partners.
I understand. They have
Partnership,
rejected.
but initially.
They have rejected your prayer, and now by the death of Satish Chandra, the entire matter
has been dissolved.
Entire purpose has been. Now the authority has nothing to do except your application like that. Okay, they cannot proceed it according to the direction of this court now. Full stop. Next paper. Having heard the learned counsel for the parties, it appears that the instant writ petition became infructuous. Accordingly, the instant writ petition is disposed of.
But I have the petition. Supplementary. Blood, the petitioner blood applied for blood a fair price shop blood, and thereafter blood his prayer was blood. The only blood intimation was given blood online that it has been rejected. No cause blood was supplied to us. The subsequently blood we have filed an application under the RTI Act, and later on blood during the pendency of the blood proceedings, blood they have replied that the approach road is brick made and 6 feet wide, and that is the sole reason blood it was rejected. Blood I have filed a supplementary affidavit blood which I have already blood.
Without leave of the court, your lordship.
Yes.
No, the party.
Blood the cause your lordship would kindly but that's their document blood. It's not my document blood. Your lordship would kindly take blood page 59.
Not been given also.
So far, blood, the other criteria are concerned, blood. Your lordship would kindly take blood annexure P6, page 59.
Rejected.
But it is only rejected. No, why rejected, blood? What are the
reasons are not
reasons, blood? That reasons were not there. But subsequently, blood, as I said, blood, on blood RTI application, blood, I have come to know, blood, that your lordship would kindly take note of the document. Blood, I'm giving a copy to my learned friend, blood, for her perusal, blood. Definitely, blood, only for perusal.
Only for perusal.
No, if you need instruction, I'm going to get a copy.
May I very humbly submit before your lordship without wasting any further time of this court. Kindly takes this up day after tomorrow, when I will be in a position to argue on this supplementary affidavit also. Whatever it is, let us have a look with how can you.
I'll just show your lordship blood what they have replied. Your lordship would kindly take blood page 5 of my supplementary affidavit. Blood, since blood they have replied, blood, I am not taking the point, though blood I have made my case blood in the writ petition that there was no reason explained, that was a ground. But since blood they have replied, blood, to assist your lordship, blood, I have annexed the document.
10-ton truck was not approachable up
That's
go down. That's the reason.
The 10-ton truck is not blood approachable. Your lordship would kindly see blood the subsequently the person who has been alerted. There are flaws and lacunas. They have skipped that, and Lord, the person who has been allotted is a relative of blood the local, a person who is in power in the local body. Blood they can equate with the blood benefits or not the infrastructure I am having and the person who has been allotted. But there is a discrimination to that extent because I own the land, I own the land. He is having a land on lease. That where blood he has been allotted, that's a blood agricultural land. Blood I have all these documents.
Now what you want?
Blood I want
Let them file their report.
And that is what blood I'm beseeching your lordship blood to ask them blood, because your lord by this time blood the government has formed blood the guideline blood, your lordship has come across with the guideline blood which says blood the marks blood points there blood there is a provision for small cars also blood which can reach to my blood place.
I shall
But
deal with this matter after a reply with
your lordship would kindly do so blood.
Okay.
Your lordship would then kindly take blood my supplementary affidavit on record and blood I have given
I
a copy
have
of my
been
land.
served a copy today. Kindly.
Okay. Leave is granted to the petitioner to file supplementary affidavit. Copy of affidavit. Copy of such affidavit be served upon the learned counsel for the respondent authority. Full stop. Concerning the submissions of the parties, it appears that the instant writ petition cannot be disposed of without giving the opportunity to the parties to file affidavits. Thus, hence the state is directed to submit a report in the form of affidavit, a detailed report in the form of affidavit within 3 weeks.
And locus and maintainability kept.
Okay. 3 weeks.
I am the agreed person.
Very
What is
very
the locus
very-
blood?
Okay. 3 weeks. Reply, if any, by the petitioner within 2 weeks thereafter.
No, 1 week, Lord, because
Within
your
1 week
lordship would kindly, Lord, I'll be beseeching your lordship, Lord, to maintain a status quo because of the reason, Lord, if my right, if ultimately your lordship, Lord,
The license has already been issued.
no,
Someone whose locus itself is at challenge, how can he or she?
it is on not by saying, Lord, my application was,
We will
I filed an application
on the next
filed an
date of my
application, my
submission.
application is got rejected. Let Lord the status quo be maintained.
It is
Lord.
already rejected, right, wrong, good, ugly, whatever. This will be
That
now
is- that-
decided by your lordship.
That is the
At
challenge.
this point of time, you are a rejected person.
Shouting, madam.
I'm
Okay,
not
I'm
shouting.
scared. I'm scared.
Don't be scared. Please
Okay.
don't be scared.
Very well.
If your lordship would kindly
1
see
week thereafter.
page
Reply.
15, Lord.
I pass the order.
Mal.
Reply 1 week there. Let the matter appear in the list. 24th of February under the same heading. Commission of license to any person is the subject matter of the subject to the decision of the instant.
Obliged.
Or of the subject to the decision of the instant writ court.
Obliged. Obliged.
ठीक আছে बाप रे
Fine.
बाप.
Please.
My God.
No,
Ek-
bless.
Lordship, I'm suffering from a very high viral fever and he is shouting. It
No,
is
no, you
just.
just take rest.
ठीक আছে बाप रे.
Bless.
Today let them handle. I'll just.
Yes. Next.
20 minutes, I am.
My lord, I beg to appear for the private respondent, respondent number 7.
This is my affidavit of service. Here I have challenged, the petitioner challenged the appointment of the respondent number 7. Because this was made in violation of the vacancy notification as well as the provisions of the control order. Lord, kindly come to first notice of vacancy. That is, it starts from page 22. Terms and conditions of the notice for appointment of fair price shop dealer. Starts, relevant page is page 23. Clause 4 of the vacancy notice.
Yes.
The applicant should possess a suitable godown as per the notification issued by the Department of Food and Supplies by number so and so, as amended by notification number so and so within the vacancy location for storage of public distribution commodities and running the dealership the area of godown should be minimum 400 square feet. Good. 300 square feet in case of hill areas of Darjeeling and Kalimpong district, along with covered space of 200 square feet, 100 square feet in case of hill areas of Darjeeling and Kalimpong district, adjacent to godown to be used for the office purpose and for FPS automation. There must be shade in front of the shop to accommodate at least 20 people, 5 people in case of hill areas. That is not applicable. The godown must be well ventilated pakka structure with a concrete floor. Then come to my lord, page 24. This is one of the conditions, and the other conditions is regarding the character of land. That is at page 24.
Dokan commercial bastu.
Yes. In documents regarding positional right over the proposed place of business in case of ownership, shared ownership, photocopy of record of rights, registered deed of conveyance, purchase deed, in the name of document showing character of land as Dokan commercial bastu. If the record of right is not produced, up-to-date property tax receipt and NOC of other owners in return. Here I have annexed the land documents of the private respondent upon which the godown is situated. That is at page 34. Plot number 3351. Plot number 3351, Danga.
Yes.
As per provision as well as per control order, that is amended on 29 September 2013, 2023. Kindly excuse me for marking. We land. The character of the land. Here clearly mentioned that if the land is of other character, the applicant needs to submit application for conversion on or before the date of application for FPS license, and also to submit conversion certificate within 3 months from the date of offer of FPS license. So prior to making an application, it is duty of the applicant to make an application for conversion of the license, a conversion of the land. This is clearly mentioned in 2023. Amendment was made on 29 September 2023.
So what is your submission?
Submission without conversion, number 1, which clearly.
Do you know whether he has applied for not? Whether he has applied?
No, because record is showing record. It was done on 18 December 2024. 18 December. It was downloaded from the website.
Conversion has not done by the authority, but he has applied for that.
Let him produce.
May have applied for that.
Number 1, application on or before the date of application. Number 2, within 2 months from the date of offer letter. That is when clearly mentioned.
So what is your status?
Is the unsuccessful candidate today?
Unsuccessful. But I have made an application for appointment.
So what is the area location of your godown?
Everything is as per
specification. Have you mentioned it?
Yes.
Where you have mentioned it? You have placed some record photographs. You filed an application for RTI before the authority, why your license was not granted, why the license was not granted in your favor. Then you challenge the order.
No, but it appears from the record. And it appears from the record that the license was issued in violation of the control order. Then I have a right to challenge the same.
No, you are not the person to write the challenge. You are not the agreed person.
I have aggrieved person.
So you show that you are the fit person.
I have
to give the
any person
No,
can
you
challenge
are,
the same.
you show this code that you are the fit person, or on your estimation you are the best person.
Yes.
Then you show this code that you are the best person. Show me your documents. Show me what you filed. Show me the location of your godown and everything. You file a proper affidavit. There is nothing in the writ petition. Have you said it that I have the good location, good godown,
Yes.
such square feet
Yes,
of your
yes.
godown? Still then they
Yes,
have
paragraph 6. Paragraph 6.
Till then they have rejected your prayer. No, this is the not
That your petitioner
concrete
states that
statement.
petitioner fulfilled all the requisite criteria such as go down, office space, minimum amount, and also submitted all requisite supporting documents and submitted application within stipulated period of time and paid the application fee.
Made it particular. Made it particular. Particular. What is the area? Where is the location? What is the distance of central location? Everything. But to make it clear that you are the only eligible person.
But that does not mean to appoint an ineligible person.
You have challenged
That does
one
not.
authority.
I have mentioned, I have stated, let them deny it, that it is not true. Deal with this paragraph.
No, you come with a proper application.
No, I have mentioned everything. Apart from that, I have stated in paragraph 10 and 12 and 14 that was done in violation of the rules. That is paragraph 12. That your petition, that the area of go down and shop of the respondent number 7 is less than the area mentioned in the notification for appointment of the fair price shop.
So what is your area?
I have mentioned in paragraph 6.
No. I want the particular. When you challenge one person or the decision of a authority, you have to be very particular.
That's true, but if it appears from the record,
if it appears, you have the
if it appears
down 600 kilometers.
Whatever may be, I have a go down 400. His go down is
only sufficiency is not mentioned.
Fulfilled all requisite criteria such as go down, office space, minimum amount, and also submitted all requisite supporting documents as per notification. That is para 6.
I understand, but it is not particular. I cannot proceed on your affidavit like that. I have everything. And they will come, they say you have nothing.
But only in addition with your lordship's observation, adding 2 points only. 2 points. Nothing more than the paragraph 6, which my learned friend is showing. In the jurat portion, it has been mentioned as a true to my knowledge, which is not sufficient. Second thing, this is the concept in the fair play in the joint.
Yes.
I am the authority. I am holding the right to cancel or to appoint anybody. In my eyes, whoever the fit person, being an unsuccessful candidate cannot come over here and challenge the same. And that too in a defective prayer. If your lordship kindly see the prayer, he is saying he is seeking the cancellation of the appointment. This cannot be done. If he is seriously prejudiced by the same, in that event, the offer letter has to be got cancelled. Appointment letter, nothing to do. The offer letters. This is also the defect. Now, thing is that, my lord, lordship kindly see, whatever my learned friend is arguing today is simply a fact-finding notions. Definitely, I believe the court is not sitting in an appeal to find out what is the loopholes are there, my lord. So that's all, my lord. And I whatever the, my lord, the norms are there, scrutinized lordship knows, my lord, the marks allotted, how we have done this. If somebody have not done anything at the threshold, we have a right to reject the same. This person, the respondent number 7, has applied in time and accordingly produced the record in time. Thereby, he is found out to the most eligible person, and we have issued the offer letter in favor of him.
It is the submission. But where is the documents?
I am not bound to show the document by
because I am the authority. I can.
He cannot even challenge in the
without following the professional.
Where is his application that event?
And the court
where
has
is
no
his
power,
application?
And the court has no power to look into the matter.
No, Mr.
Now, my learned friend is saying I am the authority, I can do anything.
Of course.
No,
Of
that
course.
is not
He
the
cannot do
provision.
arbitrary.
Yes, I cannot.
Correct, my lord.
Where is his
And that
application
is,
in that
it
image?
appears from the record,
You have
it
to prima
appears from
facie
the
show.
records.
You have to prima facie show there are some arbitrary.
Correct.
Yes.
So you show me the that's why I asking you materials. Where is the materials that they have acted
That the
arbitrary?
petitioner has fulfilled all the requisite
Yes,
criteria,
yes.
and in support of that to produce the documents.
Yes.
My lord, kindly
Want
give
the
me,
material.
give me liberty. As I have stated, I shall.
Yes, I can
by
give you
way
liberty
of
to sue
supplement,
afresh.
by way of supplementary affidavit, because I have stated.
Supplementary affidavit.
Yes, in support of that, I have stated in paragraph 6, because I have stated in paragraph 6.
Very well. I can allow you.
Because I have stated in paragraph 6,
You file
I shall
supplementary
submit the
affidavit?
documents only to documents.
Very well. You submit the document to satisfy the court
Yes,
that the act of the authority is arbitrary.
Arbitrary or malafide. Either of these.
Yes. That is it. That
Show me
is
the
my
prima
case.
facie, okay?
Yes.
Otherwise, I can.
That I have eligible as per notification,
Yes.
and he is not eligible as per
Leave is
notification.
granted to
This
the
is the case.
petitioner to file supplementary affidavit within 2 weeks
Yes, ma'am.
by serving an advance copy to the learned counsel for the parties. Affidavit of service filed on the petitioner is taken.
Milord, I am taking the point of maintainability. Let that be kept.
Yes. Point of maintainability raised by the learned counsel for the state.
And also by the private respondent.
And the private respondent. Be kept open.
I'm so grateful.
We have 4 item number.
Milord, may I take back the control order?
Yes. The control order. Copy একটা আছে এরকম। Next.
My application, my lord.
For the state judge.
My lord, for the petitioner. The affidavit of service be kept with him. This is the second round of litigation, my lord. My lord takes up my lord's order at page 175. Page 175. This is this writ petition was initially filed challenging the illegal arbitrary action on the part of the respondent authority in not supplying adequate quantities what is required in a fair price shop. During the pendency of the writ petition, they had issued the suspension of show-cause notice, thereafter the suspension order. The initial writ petition was taken up for hearing by my lord. The order is at page 175, wherein my lord had granted liberty to file a straight writ petition challenging the suspension order. The suspension order is at page 172 of the writ petition. And
yes.
This is the suspension order. Whereas the team of Department Food and Supplies visited at the FPS of Apurva Roy, FPS code number such and such. These are the various stocks lying are found following manner. These were the stocks which were found lying. If my lord takes up, in comparison to this page 172, the stock statements, which are monthly stock statements which are provided to the petitioner, is annexure P2, page 23. My lord, the serial number 3, Apurva Kumar Roy, 1324 PHH Rice, 12600, 51.70, 51.70. If my lord takes my supplementary affidavit, which was filed in the earlier writ petition, that is at page 163. The supplementary affidavit which was filed by the petitioner in the earlier writ petition, it starts at page 163. If my lord turns to page 157, I have in that writ petition. In that writ petition, I had filed a chart. If my lord takes up page 167 once.
Yes.
My lord,
4 kg quantity, the first column shows 4 quantity in scale, month and year. RCC count is, the next column is the RCC count. Allotted quantity, required quantity, deficit quantity. The 4 kg was supplied in the year 2022. 1324 was the RCC count. 51.70 allotted quintal of. If we multiply 1324 into 4, it comes around 52.96 quintal. And the allotted quantity by the authority was 51.70 in July 2022. Therefore, 1.26 quintal is deficit. It's an admitted fact. The chart which I have provided, the allotment chart which was provided month-wise, shows a different thing. Allotment which shows is 51.70 allotted quantity. If my lord takes up page 167, the allotted quantity is 51.70 by the authorities. As per the RCC count, I am entitled to 52.96 quintal. The 1.26 quintal is deficit. And if my lord takes up the show cause notice, why I have been issued with the show cause, or the suspension order, since I had not participated in the Duare Ration. If the quantity is not with me, how can I participate in Duare Ration?
No, they have found some
So this is totally perverse, totally illegal.
shortage of the balance.
This is totally illegal. I have demonstrated in my writ petition. If my lord takes up again the supplement.
No, you have demonstrated in respect of one.
Everything. The RCC count, allotted quantity in the year 2022.
No, it is the, I understand it is a 22.
Yes.
But they have found shortage of stock on 6th of August 2024.
That is the quantity. 6th of August, if my lord
they found some shortage.
Gives me a liberty to file a press supplementary affidavit in this writ petition, I can demonstrate that there's shortage. There's also shortage. If these continues, I have to make up this thing. 1.26 quintal, everything is shortage.
So you challenge the
suspension order.
Suspension order.
That is page 172.
Page 172. So you are saying that the list of shortage is not proper.
Not proper.
Okay. Let them file affidavit.
And in the meantime, after this suspension order, any moment, the license may be cancelled by of the petition. If a stay order is granted or injunction is restrained, the respondent not to give effect or further effect is the disposal of this writ petition 172, the suspension order. Otherwise, the writ petition would become improper.
No, nothing to do in fact. Yes, we have challenged the suspension order. If the suspension is gone, everything would be gone.
And Lordship, on behalf of the
let
state,
them decide. Let them disclose something at least.
on behalf of the state, if I may bring something to your Lordship's notice. Lordship, this order of 3/10/2024 was brought under challenge. Then Lordship passed an order where the stay was not allowed. After that, thereafter, on 22/10/2024, a personal hearing notice was given to the petitioner by the District Controller of Food and Supplies, Murshidabad. Thereafter, that hearing was conducted. The proceedings of the hearing, it's with the report, Your Lordship. If your Lordship would like to refer to, then I can give a copy of the report.
You file a report with the affidavit.
Fine. All that I am trying to say is that after the hearing, the last paragraph says, observation of District Controller, Food and Supplies, Murshidabad. Upon reviewing the facts and findings, it has been observed that despite being provided with multiple opportunities to present his case, the petitioner has failed to offer any explanation regarding the misappropriation of food grains. The records, however, clearly indicate mismanagement of stock and non-compliance with the provisions of the West Bengal Public Distribution System Maintenance and Control Order of 2024. However, after careful consideration of facts and records, the undersigned authority deems it appropriate to grant the licensee and petitioner Apurva Roy a final opportunity to present his defense. A personal hearing before the subdivisional controller, Kandi, in capacity of licensing authority, is hereby directed. It was directed within 15 days to be conducted, but very honestly, Lordship, I have not collected that report. What happened in that hearing, whether that hearing at all took place or not.
So what is
So-
the order you are reading?
I am reading from the
There is a
order
particular
dated-
hearing, page 174. If my lord takes up 174, an appeal was preferred.
an
before
appeal
the
was preferred.
appeal was preferred before the
Concerned authority.
concerned
Yes.
authority.
So Lordship, all I'm trying to say is that whatever the petitioner is presenting before your Lordship, the petitioner could have presented there. There, the recording is that nothing is
someone
being
appealed,
presented.
Appeal was pending.
Appeal is pending till no decision has been taken, madam, till date.
So what is the purpose for proceeding in the
My
writ
lord.
petition now?
Exactly.
I don't know.
Appeal is pending.
Let them
There
take
is
a
a
decision.
direction,
The writ petition
and
kept
all these
pending.
facts
madam.
are being presented here.
Why you file
the
this?
correct
What is the
form.
purpose of pendency?
Pendency
If the appeal order is against you, you have to file again. Then
And they are not presenting these facts in the proper forum. They are bringing these facts here.
so no, if you have preferred the appeal, let the appeal be decided.
My lord, appeal
If
was
it is decided your favor, so what is the purpose of the writ petition? And if it is decided against you, then you have to challenge the order also.
no next.
And this was not even disclosed that they had gone to appeal.
That we have gone through. That is annexed in the writ petition.
Then you file afresh, okay? I am disposing of this matter. Affidavit of service filed on behalf of the petitioner is taken on record. Having heard the learned counsel for the petitioner, it appears that the petitioner has approached before the concerned appellate authority against the impugned order. In these circumstances, it appears to me that the instant writ petition cannot be proceeded further. Accordingly, the instant writ petition is disposed of as not pressed. Petitioner has at liberty to sue afresh on the self-same cause of action.
And my lord, a direction may be given upon the authorities to dispose of the appeal within a time frame.
You have not mentioned the appeal or
No, that's
come
the-
before this before this court to dispose of the appeal within time.
There's a prayer in my writ petition. madam.
That prayer is 310. That is related regarding 310. I do not see any prayer regarding the
In
appeal.
respect of appeal,
That prayer is not relating to the appeal order, Lordship. If Lordship may come to page 16,
there is
A.
no such prayer. Is there any prayer?
directing the respondent authorities to withdraw, recall, and set aside the order dated 3/10/2024.
There is so-called
After that,
suspension.
the appeal that was already dealt with.
You have not challenged the appeal.
The appeal, the order of the appeal has not been communicated or the hearing is pending before the appellate.
Then you dispose of the hearing.
My lord, a direction be given to the appellate.
No, you have not challenged with the authority to dispose of the appeal in time. Very well, no order. Next,
At least record the appearance. Twenty-one, no order.
No order, no order. As regards to the application.
Oh.
Wait, as regards to the applications. Happy.
Sure, item number 22, my lordship, I am the petitioner. My lordship, I'm praying for the not this week, my lordship.
not this week.
Please, my lordship.
Come on, next week.
Yes, my lordship.
Next week we have only one day, Wednesday. Very well.
The 23 appear for the petitioner, my lord.
Yes,
This is
your
one of those notification matters, my lord.
I appear for the state, your lordship. I am led by Mr. Ojun Rampuji.
But may I, my lord, file the affidavit of service?
Notifications matter.
Lord, my license, your lordship will find at page 22, my lord. And the notification at page 35. My representation at page 39.
Annexure 5.
P5, my lord.
Same notification.
Page 35.
Same notification.
It has been annexed twice. I also got confused. It has been annexed with the license and then, my lord, as in annexure, my lord.
Similar direction, notification. 1243 of 2020. MAT 1243 of 2020. Similar direction.
I shall, if required, I shall give a.
State is directed to file the affidavit in opposition within 4 weeks. Reply by the petitioner within 2 weeks thereafter. Full stop. Considering the facts and circumstances of this case, the state is at leave to proceed with the selection process, but so far as the grant of license is concerned to any person which shall not be commissioned till the disposal of the batch of appeals pending before the learned division bench, being MAT 1543 of 2024. Let the matter go out of the list, but
But if required, my lord, I shall give a sample order to your lordship's officer, my lord.
not necessary.
Not
I'm for the petition.
Millet, with utter humiliation, I am praying just one day time. I have lost it. The PDF came. I lost it. It's my responsibility. Kindly keeps it up tomorrow. I will come up and show.
Okay, but come on. Not today.
Then may I file the affidavit of service, ma'am? Very good. But the
Yes, where is the report?
Your Lordship, we have not received the instruction yet, Your Lordship. Report.
Your Lordship, praying for extensions of filing of report, Your Lordship.
Today is the date for filing report.
Yes, Your Lordship, but I'm praying for extension, Your Lordship.
Have you received any report? Any intimation?
Your Lordship, this is, I'm not properly
is a
informed with the
very
matter, Your
simple
Lordship, but
matter. This is-
my senior has come today, Your Lordship, but she has left the court because she was not feeling well, Your Lordship.
Otherwise,
It's
a
altogether
very,
separate issue.
otherwise a
Yes, Your
very,
Lordship, but I,
very simple.
in the
Take the instruction. What is the matter I have to do with this matter? It's very short matter involved in
Yes,
this
my lord,
matter.
very short matter. And I have, my lord, disclosed, my lord, all the documents. Everything is on record, my lord.
Mr. Suman Sengupta was leading in this matter.
Yes, my lord.
You are leading in this matter.
Amrit, no, Your Lordship, Amrit Lal is in this matter, Your Lordship.
Lal Chatterjee, not that.
But the recording of Mr. Sengupta is there.
এটা কোন কি ম্যাটার এটা?
With Amrita Paja Maulik.
No, compassionate.
Whether Mr. Chatterjee is there or Mr. Sonu.
No, Chatterjee sir.
Name is there, Mr.
May I see the order once more? Because thank you.
Nirmal Molla.
No.
Not
I-
Nirmal Molla.
No.
No, that is a new one, my lord. That is a new one.
কোন রেকর্ড দিয়েছে?
That is a new one, my lord. That is a motion.
This is Kobita Mondo.
Yes, my lord. Kavita Mandal, my lord, for appointment on compassionate grounds, my lord, may I take your lordship, my lord, through the documents, my lord? Simple matter, my lord. I am, my lord, the daughter of the deceased license holder. License, your lordship will find at page 12, my lord. And all the documents along with the application, my lord, lordship will find, my lord, page 15 onwards. And well, first, my lord, I'm sorry, first the death certificate, my lord, that your lordship will find at page 13. Death certificate, my lord, Bijoy Kumar Mondal, my lord, who was holding a license, my lord. Then if your lordship turns over to page 15, lord, my application, page 15, and with the application, my lord, are all the documents, my lord. Page 22, my lord, is the affidavit, which your lordship knows, my lord, has to be sworn, my lord, before the first class magistrate. Page 24, my lord, is the no objection from all the legal heirs. Page 28, my lord, is the registered lease in my favor. Page 42, my lord, is my bank statement, my lord, which shows, my lord, sufficient amount. Page 43, my lord, is the airship certificate. And my lord, I am a scheduled tribes, my lord, category, my lord, that your lordship will find at page 44. But I have given several representations, my lord, starting from page 54 to 57, my lord. And my lord, page 61, if your lordship comes to, my lord, in fact, there is a recommendation. Kindly come to, my lord, page 61, my lord.
61.
61, my lord.
Yes.
My lord, all documents annexed, my lord. This, my lord, is being written, my lord, by the sub-divisional controller to the district controller. Application of Kavita Mondal, daughter of late Bijoy Kumar Mondal, deceased so-and-so. Then, my lord, with due regards and submission, this is to bring to your kind knowledge that Kavita Mondal of village so-and-so, the daughter of the deceased MR dealer Bijoy Kumar Mondal, gives submissions before the office to consider her name as licensee for the dealership of her deceased father's MR shop on compassionate ground due to her abject, staggering financial condition and invalid, infirm husband. She informs that she lives in her parental house and she is supported by her brothers for her living. Her other siblings have pledged before the first class magistrate that they do not have any objection or excuse if the dealership is conferred upon their sister. Then, my lord, next, my lord, I personally inquired into the matter to the satisfaction of my office in terms of the requirements by the rules and norms and formalities to recommend for her the said license. Well, sub-divisional control is the licensing authority. And in all cases, my lord, the state say, my lord, it is after due inquiry of the sub-divisional, my lord, that an order is passed. So in this case, my lord, then your lordship turns over, my lord, page 62 is the notice of personal hearing. My lord, given to my other legal aids, my lord, and to me as well, my lord, number 1, Kobita Mondal. Then your lordship turns over, my lord, next page, from the deputy director license to, my lord, the sub-divisional controller. Then, my lord, enclosed, please find herewith a list of cases regarding engagement of FPS dealer on compassionate ground, which are lying pending at different levels for a long time. My case also, my lord. Then, my lord, if your lordship sees, my lord, the list is enclosed, my lord. My name appears as serial number 11. Yes. Same page, serial number 11. And if your lordship turns over, my lord, the attachment that this letter talks about is at page 64, my lord. My name, my lord, is, my lord, 1, 2, 3, third. Kavita Mondal. Date of application, my lord, 28/3/2022. Yes. So, pursuant to this, my lord, the hearing was held. If your lordship comes to page 65. From the joint director license to Srimati Kavita Mondal, wife of so-and-so, the undersigned is directed to inform that the director DTPS will hear her through video conference so-and-so from his office chamber, Khaddoshri, in connection with her application, my lord. So, I have attended this, my lord, and nothing after this, which has compelled me, my lord, to come before your lordship, my lord, praying for, my lord, her appointment on compassionate ground. If they do have an objection, my lord, of course, they will, my lord, come before lordship and disclose their objection, which I don't think, my lord, they should have, because everything is on record, my lord.
After hearing, what is the outcome? I am not.
That he is supposed to say.
But you kindly direct this joint director of wrestling consider and.
Now I have come before lordship. I have waited a lot, my lord, and now I am before my lordship.
There's a process
I have
going
disclosed.
On, what is the reasoning is there, my lord? I am not.
This process, my lord, has already taken, my lord, years. This too, my lord, is of July 2024.
When Bijoy died, Bijoy expired when?
That your lordship will find from the death certificate which I have, my lord,
what is the
disclosed?
Date? 2012, perhaps, my lord.
2007, my lord. 14/11/2007.
2007, my lord. Today,
Thereafter, my lord. Thereafter, the
long pendency.
Also, kindly direct, my lord. Also, prayers is also otherwise, my lord.
Where is your application?
Dispose of the same.
My application, my lord, your lordship will find at page 20, at page 15.
See the prayer, my lord. Prayer
15.
C.
Oh, it's a day 22.
Yes, because in the meantime, my lord, since I am completely dependent on my brothers, my lord, my brother's wife had applied. But 3 writ petitions, my lord. And I could not say anything because I'm completely dependent on. I cannot even say no. I'll apply. Those writ petitions have been disposed of, my lord, and now I have come into the picture.
Okay, you come with a positive report.
Yes,
See,
lord.
instead of that, my lord, lordship is my.
No, I let them come, my lord, because
65,
otherwise,
my lord.
again, my lord, I go
65,
before the
lordship.
authority. The authority takes
will
time, my lord.
consider in the light of this notice, hearing notice, my lord. What is the outcome?
No, hearing notice was done.
Well,
They have
lordship,
heard it.
Perhaps
you
the
have
hearing
heard
was,
the person.
hearing was done, my lord. And what is the outcome if my lord detects this Joint
That's
Director
why I
license.
want the report.
Yes.
That's why
It's
why the
If my lord
again
it-
he will appear.
if my
He
lord
will
it does
appear again. The same will be done.
Lordship,
You have already taken a decision, I think.
Lordship is
Okay, this is July 2024.
yes, see, my lord is
Long
saying that
pending.
the application and representation
Lord-
made by the petitioner and dispose of the same, my lord, in accordance with. If my lord directs that, that will be better, my lord.
Well, let them come back, my lord, with the
Okay, you come with
instructions,
the
my lord.
report. What is the matter?
Your husband, my lord, is suffering from life-threatening disease, my lord. No, no,
Okay, okay.
he's in complete financial crisis, my lord.
Please take down. Petitioner challenge the action of the concerned authority for not taking a prompt decision in respect of his in respect of her application. Prompt decision in respect of her application for license, for MR license under compassionate grounds. Full stop. It appears that the authority has already heard the petitioner on 13th of July 2020. 30th review. 30th of July 2024. No decision has been intimated to the petition. Considering the long silence of the authority, full stop, the state is directed. No, I think it's necessary to.
My lord, 7th August, my lord.
It should be, my lord, has heard on 7th August.
7th August, my
30th
lord.
July is the
7th
date
August.
of the, yes. 30th
7th
July.
August. 7th August 2024. 30th, 7th August 2010. Considering the situation, I think it necessary to pass a direction upon the concerned state authority to submit a report to the concerned respondent authority to place a report in respect of result of the said personal
What is
hearing.
the outcome of this hearing?
Outcome of the said personal hearing held at the chamber of
Joint Director license in DDPS, my lord.
Joint Director license.
Yes, my lord.
Joint Director within bracket license. DDPS.
DDPS.
DDPNS dated 7th of August 2024.
Grateful, my lord.
Let the report be placed
Lordship.
within 2 weeks. Let the matter appear in the list. 17th of February.
Grateful, my lord.
Affidavit of service filed on the petition is taken.
কি নাম আছে দেখুন 27 রেড পেটিশন নাম
নজরুল ইসলাম
আচ্ছা ঠিক আছে 27 will appear for the petitioner, my lord. May I file the affidavit of service, my lord? This is, my lord, again one of those notification matters, my lord.
Notifications matter?
Yes. License, your lordship will find at page 22, my lord. Notification at page 31 and representation at page 35.
Village Monir Tala. Okay, please take down. Similar order, the order go high. Yeah. Okay. The following question to policy. Having heard the learned counsel for the parties, the state respondent is directed to submit a report in the form of affidavit within 4 weeks from date. Reply, if any, within 2 weeks thereafter. Full stop. Considering the facts and circumstances of this case, the state authority is at leave to proceed with the selection process, but so far as the grant of license is concerned, the same shall not be commissioned in so far as the grant of license is concerned, the same shall not be commissioned in favor of any person till the disposal of batch of appeals pending before the learned division bench of this court, being MAT 1543 of 2024. Let the matter go out of the list, particularly of mentioned. The bidder satisfied on behalf of the petition is taken.
Grateful, man.
Third, item number 14, Lordship had passed over, my lord. My lord, friend has, my lord, come with instructions, my lord, from the office of the BDO, my lord. That is with regard to, my lord, the private respondent, my lord, being one of the members of the Panchayat Samiti.
What is the item?
14.
Have you got any report like that?
My lord, we have sent notices to BDO. I've had a talk with BDO as well. My lord, the BDO has informed me that the person concerned was elected as Panchayat Samiti member. Now, in our records, we cannot find that he resigned before filing this application. We have also called that person, Mr. Anwar Ali. That person says that I resigned, but he cannot produce any received copy of that resignation letter, which according to him, he has submitted to the BDO office. BDO office does not have any such resignation letter. So, my lord, the presumption which comes from such records, my lord, is that that person was a Panchayat Samiti member because he cannot prove otherwise. From the office of the SCFS, my lord, on 21st of January, after the matter was last taken up by your lordship, my lord, we also sent a notice to the private respondent saying that you must produce a proof that you are not a member of Panchayat Samiti. My lord, we are yet to receive any such proof from his end.
And he's
Lord,
not
this is
even
the-
appearing before your lordship, my lord.
Have you served the
I have
served
filed
upon the
the-
private respondent?
Yes, I have
This is
filed
the
the affidavit of
notice, my
service,
lord,
lordship,
which we served upon the private respondent on 21st of
the
January.
private respondent is aware of the proceeding, my lord.
Physically,
Because of
it
the
was
letter
served
also.
today, but my lord, on that day he refused physical service. It was served through WhatsApp as per my instruction on 21st of January.
Evading service, my lord, because
So
Today it was physically served. He has received today on 27th, and my lord, on WhatsApp it was served on 21st of January.
or my lord, may I say this, my lord? Should I, my lord, just write a letter to the private respondent once and fix, my lord, lordship will fix the next
Yes.
date. I shall write to him, my lord, and say, my lord, to appear on that date, my lord. In default, necessary orders would be passed.
He has not been able to produce any such resignation letter which he alleged that he gave before filing this application. He said that he resigned from the post of Panchayat Samiti member.
Let him appear, my lord. Let him appear. Lordship, you keep fixes a date, my lord.
But we have inquired from both the authorities. They have no such record. And my lord, in his affidavit, he has averred that he is not a Panchayat Samiti member. A mandatory affidavit, he has averred that he is not a Panchayat Samiti member. But no such resignation or the fact that he was elected in 2018 was ever communicated to us.
Please take down. In favor of respondent number 6 is the subject matter of challenge. Respondent 6 grant of FPS license. FPS license in favor of respondent number 6 is under challenge before this court. Sole ground for challenge the license is that
there are other grounds
yes,
as well.
That's one of the grounds. One of the grounds.
The main grounds for challenge the license of respondent number 6 is that the respondent number 6 allegedly was Panchayat Samiti member.
Yes, my lord.
At the time of filing the application for getting license. Full stop. Next para, Mr. Ritesh Kumar Ganguly, learned counsel appearing on behalf of the state, submits some instruction that though several intimation was served by the concerned department to the BDO, to the concerned BDO, but video regarding the fact that whether respondent number 6 is a member of Panchayat, is a elected member of Panchayat Samiti or not. Full stop. No report is received from the video. Not. Full stop. No report is received.
But the video has informed today that no such resignation letter is there in the Lord, he'll issue such report.
Mr. Ganguly, full stop. This is received. Mr. Ganguly submits on instruction that concerned video has informed that no resignation letter was submitted by the respondent number 6 to the before the video regarding his resignation from the membership as Panchayat Samiti. Full stop. Having heard the learned counsels for the parties, the petitioner is directed to serve upon the private respondent number 6, informing him that the matters shall appear in the list on 18th of February. 18th of February.
Can your Lordship give a short date? Lordship would not be here.
No, I am here always.
Then Lordship will give a
18th of February means the second week. Give him 1 week chance at least. You
We are
serve
already on
you serve
28th today, 27th today.
Today
we have
27. Next week we have only 3 days. I am giving a 1 week then. Thereafter on the next week. Okay.
As your Lordship, please. 17th February. 18th February.
My petitioner father, HON'BLE Kumar Samant, was the fair price shop dealer. If you Lordship kindly turn to page 22 of my petition. This is the license which was granted to my deceased father, HON'BLE Kumar Samant.
Yes.
But father died on 7th of August 2018. Kindly turn to page 24. Third column left hand side, date of death. And above that, HON'BLE Kumar Samant died on 7th of August 2018. Have a look, my lord. I applied for license and license has been ultimately granted to me on 1st of January 2022. I have annexed the present license at page 25.
Yes.
I have stated in para 6, page 4 that initially license has been granted to me 1st January 2022. Then it has been renewed time to time and this is a renewal license. Now, from the date of my appointment, I have been given lesser quantum of ration articles. Kindly turn to page 27. This is a letter of 12th of July 2021. Kindly see. Addressing to the sub-divisional controller, I am reading, my lord, the second paragraph. মহাশয় আমার সুবিধা আবেদন এই যে জুন 2024 19 তারিখ পর্যন্ত ইপোস মেশিনের পাওনা রেশন সামগ্রী দুটি মোট স্বয়ংস চাল ও স্বয়ংস আমার প্রাপ্য আমি যাহাতে উপরোক্ত সামগ্রী পাইতে পারি তার সুব্যবস্থা করিয়া আমাকে বাধিত করিবেন। নেক্সট পেজ, সেম লেটার, ইচ অ্যান্ড এভরি মান্থ উইথ ডকুমেন্টস। Then kindly turn to page 35. What is the intimation? Kindly turn. Page 35, this is the communication of 25th of October 2024. You kindly take pain to go through the entire document. This is a reply against your letter that we have placed before Lordship. With reference to above, this is to inform you, your Lordship, at page 35.
Yes.
With reference to the above, this is to inform you that you should award the deduction of closing balance depends on transact done by EPOS machine only. You got fair price shop license on compassionate ground from your father, that is HON'BLE Kumar Samant, and you started transaction by you on ID number so and so from February 2022. It means last transaction done by you was January 2022. So normally all closing balance of food grains at HON'BLE Kumar Samant must carry forwarded at your end, and you could not claim because you have got license from him on compassionate ground. In this regard, closing balance of your father up to so and so is enclosed herewith for your ready reference. Apart from that, in respect of NFSA and RK Rajya Khadya Surakha Yojana scheme, you started by your ID from so and so, whereas allocation was issued by headquarter against your father's ID same month. For the reason after transaction for the month of 2022, your closing balance became negative and you excess amount of allotment in every category of so and so excess amount of food grains as per category. Well, this table has been given. Then this is very important. Last paragraph. You know that subsequently amount of PMGKY items has been adjusted with normal NFSA scheme, whereas RKSY who has been adjusted RKSY rise. For this reason, in stock transfer report, PMJKY item of RKSY which was not available. Moreover, this excess amount of food grains, this is very important, is adjusted with present balance of closing balance. Apart from that, you signed, kindly take note of, you signed on the transfer report of 25th June 2024, as so you cannot ignore. Kindly take note of, my lord, this one. Most of you should know that in respect of compulsory appointment, existing dealer is complied bear all closing balance of his erstwhile dealer. So you are fully responsible to arrange the closing balance, and moreover, you must have proved that all food grains against every consumer so and so your demand so and so. But pausing for a moment, two things. So far my signature is concerned, I have already lodged a FIR against the sub-divisional controller. These are not my signature, I shall show to your lordship. Fact remains, my father died in 2018, license has been granted to me 2022. This is the usual practice. The moment a dealer terminated his license, died or suspended, immediately that is being tagged with the nearby dealer. None knows who will get the license. I may apply, I may not apply, or third party fresh vacancy can be done. So the moment dealer is being tagged with other dealer due to termination or death, all goods automatically residual stocks is being given to the said dealer, and it is in his account, because department does not know whether son will apply or sister will apply, or after 5 years they will get the license or not. This is the usual practice. The dealer with whom these cards are being tagged, he took the residual stock from the deceased or terminated dealer, he distributed through his deposit machine. It cannot say after 4 years, when I will get the license, all this balance will tag with me. It cannot be, my lord, because none knows who will be appointed in place of my deceased father. If any fresh vacancy is declared, a fresh candidate is appointed, then these goods cannot be transferred to his account. So it is a normal practice, usual practice, existing practice. All goods, residual goods, immediately should be transferred to the person concerned with whom it is being tagged. So far, my signature part is concerned, this says I cannot ignore it. I have to accept it. Kindly turn to page 47. Before that, my lord, kindly turn to, my lord, page 50. These are the documents according to them I have signed. Kindly see balance Sudhanshu Shekhar Samanto. Page 50, second column. Item name, then balance Sudhanshu Shekhar Samanto. That is my client. Balance of Amulya Kumar Samanto. That is my father's name. But these balance have been tagged with me, that add with me, and it becomes 4533. Kindly say, so far my balance is concerned, PHH rice minus balance, minus 77.633. So far my father's balance, they are showing 375. If your lordship deduct 375 minus 77, then it will become 4523. Like that, 308 minus 308, so far PHH Atta is concerned. So far my father's balance, 534.
No, PHC rice is 77.
PHH rice is 7. I'm showing now Atta.
Atta.
Atta is minus 302 in my account. So far my father 534. It has been deducted and it becomes 231 positive. Like that. And kindly see signature Sudhanshu Shekhar Samanto. Kindly come the next page. It has been signed by the subdivisional controller. It has been signed by the inspector. Again, my lord, the same thing. My signature has been given, Sudhanshu Shekhar Samanto. Next page, kindly see page 52. Signature of the licensee, Sudhanshu Shekhar Samanto. Signature of the inspector. Left-hand side signature of the subdivisional controller. But these are all false signature. What I have done immediately after coming to learn, I lodged a FIR against the subdivisional controller. Kindly turn to, my lord, page 47.
All false signature.
All false signature. I shall show. It is apparent. It is apparent. They are the food officials. West Bengal Food and Supply Services, subdivision controller. Kindly come to page 47. I went to police station. They refused to accept. I lodged it by speed post. Page 47. To the officer in charge, Bhagwanpur Police Station, Purbo Mednipur. Stock statement so and so. Date I have given. মহাশয় আমি সুধাংশু শেখর সামন্ত সোয়াংশ একজন রেশন ডিলার হইতেছি আমার এফপিএস নাম্বার সোয়াংশ গত তারিখে খাদ্য দপ্তরের একটি বিবৃতিতে আমার স্বাক্ষর জাল করে আমার ফ্যাপ্রাই শপ মেশিনে অনেক পরিমাণ রেশন সামগ্রী আপলোড করা হয়েছে বিরতির একটি করে বগলি চিঠি জুড়ে দেওয়া হয়েছে আপনার অবগতির জন্য কিভাবে খাদ্য দপ্তর আমাকে না জানিয়ে আমার স্বাক্ষর নকল করলো তার জন্য আমার কমপ্লেনটি নেওয়ার আবেদন জানাই দয়া করে আমার আবেদনটি গ্রহণ করিয়া আমাকে বাধিত করিবেন। But this is the letter I have sent speed post, page 48, and officer in charge office received it, page 49. Kindly see, item delivered 9th of December 2024 at 18:01, page 49. Have you also got it? Kindly see once again the signatures. Straightway kindly come to my lord, one of the pages, page 51, 52, and 53. Kindly see page my lord 52. The signature of the subdivisional contract area inspector is concerned Sudhanshu Shekhar Samanto. Kindly tally it with page 21, my affidavit portion. Page 21. How does it tally? Kindly see. Apparent. I lodged FIR against the subdivisional controller. Kindly come to another signature of my representation. Kindly turn to my lord, page 58. I shall read this letter also. Before that, kindly tally the signature, 58. And 47 is also there. 58, kindly see. Signature tally with the communications, page 50. Does not. Page 47, also there is a signature. It is apparent. No expert is required.
So what your prayer here?
My prayer is that, my lord, let there be an affidavit by the director in this case, because I lodged a specific complaint. Kindly turn to my lord, page my lord, last annexure, page 54. Kindly come. Well, this is addressed to the director, district controller, and subdivisional controller also. Kindly turn to page my lord, 57. This is the elaborate representation. Page 57, last paragraph. That from the memo dated 25th October 2024,
Yes.
issued by the subdivisional controller food and supplies, I came to learn that I have signed in those two printed documents. Accordingly, I could manage to collect the copies of those documents from where I came to learn that in those printed documents, forged signature had been endorsed. Accordingly, I went to the Bhagavanpur police station on so and so to lodge a complaint, but the officer in charge Bhagavanpur police station refused to accept such complaint. Accordingly, the said complaint dated so and so has been served upon the officer in charge of Bhagavan police station by speed post on so and so. This is a specific complaint with the director. Forged signature. Unless I sign, he cannot deduct.
No, whether these documents you have received or you have submitted.
They have supplied it along with the communication. Kindly come.
They have supplied to you.
Yes, they kindly come to. They have disclosed it. Kindly come to page 35. They have disclosed it, not supplied to me. Kindly come to page 35.
Okay, page 35.
Yes, second paragraph. You cannot ignore. Kindly say, apart from third line, right hand side. Third line, right hand side. Apart from. Have you also got? Bottom, second paragraph. From bottom, from top, third line, right hand side. Sentence starts, apart from.
Yes.
At page 35. Apart from that, you sign on the transfer report on so and so, so you cannot ignore.
So what is your prayer here?
Let them file an affidavit in the meantime not to deduct any articles, and the director may be directed to file an affidavit. November, December, January has already deducted. It cannot be, my lord. My father died in 2018. I got the license 2022. After 4 years, they all on a sudden says, your father has this type of stocks, so you have to carry it. This is not the procedure even. In every district, every subdivision, this thing is going on. The person concerned with whom these cards have been tagged, immediately entire goods shifted to him. He became the responsibility to supply the ration articles to the tag dealers of the original dealer. After 4 years, you cannot say, had I not been applied, who will be responsible to so far these goods are concerned? The newcomer cannot be forced. In one case, Your Lordship, please direct the director to file an affidavit, and in the meantime, not to deduct any further. My learned friend on last occasion appeared in this matter and to submitted before Lordship that he will take instruction. I cannot deliver the goods. That's my specific case I have made out. The consumer is the most priority.
Okay.
My lord.
First of all, this is a very hypothetical question that had it been a case I have not appeared. That cannot be considered. Here, the problem remains a person concerned who is holding up a license and appointed under the compassionate categories. His father is holding the license and having the stocks. Naturally or otherwise, this stock has not got adjusted with the present distributors. Now, accordingly, Millard, what we have done, since we have find the animal, I will also show to your lordship, Millard, what are the animals over here. So we have decided to deduct the stock, to deduct the same as per the 25% basis or otherwise. We could have been asked for the 100% in a one go, but we have not. Chooses, not to. Now, the second thing is that, so far the deductions are concerned, we are quite aware that the deduction would affect the general people at large. We know that, we are quite aware of. This is the excess amount which has been getting paid. After the EPOS machine has been installed, we are adjusting the stocks only. This is the factual aspect. Now, so far the signatures are concerned, lordship kindly peruse. He is saying, he took in one hand, he is saying that my signature has been forged. Now, in the other hand, in a later dated 22nd October, he said that some Bhuturia stocks has been given to me. So in one hand, he is accepting the same. On the other hand, he is saying, look here, this is not my signature. Well, this is the confusing. Lordship, kindly see, and conflicting as well. Kindly have a look into the letter. বলতে হবে না 22-10 page 28.
But I have annexed it, page 28.
Yes.
Why the loose sheet? To make more important.
Yes. So in one hand, my lord, he is saying somehow my signature has been forged. Now the question is that whether the signature has been forged or the department has acted in a bona fide manner, this cannot be decided in that manner. Lordship has decided this issue. Lordship has delegated this matter to the district controller to decide the same. I just placing up the judgment of your lordship, Millard. Let that be decided in that manner as well. Lordship, kindly have a look. It is passed by your lordship. What's
Unreported judgment.
No, এই তো দাও না দেবো না দিয়ে দিচ্ছি দেবো ওটা না দেখছি আমি না তোমরা না দেবো Yes, absolutely imperative, my lord. This has been covered absolutely in toto. The dispute as regards to the Millard, curtailment of the Millard, the allotment. Lordship has decided the same. Now today, what my learned senior friend is asking, that let a affidavit be filed. But affidavit, by filing the affidavit, I believe Millard, this disputed question of fact cannot be Millard adjudicated in that manner. Let that be decided by the district controller within a time frame which your lordship has held. In the meantime, if it is being found that these subdivisional controllers have acted in malafide or otherwise, naturally everything will go.
If you don't want to file an affidavit, your lordship, director, hand regulating expert. to submit a report. Why he is so fear?
I am
There
not
is
at all
hundred
fear.
of instances when court feels to send the matter to a 109 expert to say whether that signature is genuine or false. This is my specific case I made out before a writ court that these are not my signature, and relying on that signature, you have deducted the goods.
No, Mr. Sara, you have proceeded to a criminal proceeding. That is the separate issue altogether.
Let them file an affidavit saying
Well,
the director
criminal
is the
case
free
cannot
power.
be
The
expedient
how
in that
this
manner.
signature has been obtained by the subdivisional controller.
That decision can be taken up in the criminal
Right.
matter or otherwise. That
No,
is
so
not
far,
the-
my lord, the signature is concerned, my lord, there are judgments. The court can direct the handwriting expert
But
to
that is
submit
not
a
the
report.
subject
And you
matter.
have proceeded to the filing an FIR.
All right, let them file an affidavit by the director dealing with my allegations.
Then the director be decided the issue by taking the note of your signatures and allegations.
Everything can be decided by them.
And so far, the deduction is concerned, that should be stayed because on 22nd, your lordship already passed an order in identical matter that consumers are effective.
Consumers
Consumers must be.
Well, sorry.
Just consider, today they are giving me 20% less. I have been appointed in 2022. EPOS machine introduced 2019. They are saying after introduction of EPOS machine, they are doing so. Last 3 years, they say tight over the matter. All on a sudden, 20%. Where form I shall deliver the goods to the consumers. Your lordship may direct the director to consider my representation elaborate, and in the meantime, not to deduct till such decision is taken.
Wait.
Because in my representation, I have categorically stated, so far the signature is concerned also.
Yes. Everything
Page-
is there. You have released the
Page
signature.
54. This is 9th of December. Specific allegation with complaint with the local police station. I have annexed the complaint also with my page 58. So far the FIR is concerned.
Page 54.
Page 54 it starts, page 58, enclosed as above, that is the FIR.
Okay.
Page 58. Kindly see page 58, first paragraph. Police station by speed post on so copy enclosed.
Yes.
May I just sum up? With the handwriting expert or otherwise, it will be the adjudicating the criminal issue. This possibly the overlapping of the procedure is not acceptable here. Second thing is that, my lord, if your lordship relegating the same to the appropriate authority, my lord, in that event, the appropriate authority is competent enough to see the everything, and whether the claim of the petitioner are German or unsustainable, that is also to be decided. Now, kindly bear in the mind, no consumer has come up before your lordship by saying that we have been affected. It is his voice, he is echoing. Now, we keeping in the mind, this is a public distribution system at large. We know, Millard, they are the distributors. Now, if we find any anomaly from the distributor's end, Millard, we have to take steps. This cannot be, Millard, at the whims of the Millard distributor, the deduction can be stopped. If it has been found afterwards, giving the opportunity of the hearing that yes, we have done it illegally or otherwise, then definitely the person concerned who have done it would be held responsible for the same and will be punished. But if it has been found that yes, of course, the person concerned or the MR dealer has acting in the contrary with the law, then what happened? I'm asking myself. না হয়ে গেছে আমি আর কিছু বলবো না আমি কিছু রিপ্লাই তো আমি বলেছি ওটা কিছু হয় না
At least just to consider the consumers, because I have 5,000 cards, more than 5,000. Who is scale is well at 5 kg, I am giving him 4 kg and 800. So they are not coming before the court. And then knows everything. Actually, they have been suffering. Only for benefit of consumers, in the meantime, not to deduct. Within 1 month, director may take that decision. Already you have deducted for 3 months. And on 22nd, your lordship also passed the similar order. And I am not a distributor, I am a dealer.
District controller is respondent number 4.
I am requesting my lord to the director because the higher authority. Possibly my line will not oppose.
No, you have filed the representation
To the director. To the director.
The director?
Yes.
Or the
yes.
district controller?
Yes, no, director. Kindly come to page 55. 4. First addressee is the director, page 54. But
You have some
yes,
application before all the authorities.
yes, but the director is the first person. Because this is the case where district officials are involved.
May
It's
I?
my case.
Although this cannot be permitted from my end, I believe the district controller would be appropriate authority because why I am saying so. Why I am saying so. The director is the overall authorities of everything. Now I know I conceded to that. Now this has been done by the subdivisional controller. Above them, the district controller. So we can go step by step. Overlapping of the steps, I don't think this is appreciable.
Controller is a district magistrate or
No, district controller is a different.
Food.
Yes. Is above the yes.
Well, every data is being kept in the head office. Every data. It will be better for the director to take these data from the headquarters and match it with the district matching data. That will be much better.
Very hard.
অ্যাপিল প্রফেসরটা বললে পড়লে পিটিশন আবার করবে বলে
One Amullo Kumar Samanto was a MR dealer.
I just come back.
Yes.
I am also taking a short leave from you.
Who expired on 7th of August 2018.
Just take this. Give
Petitioner, being son of the said deceased MR dealer, was given license on compassionate ground in the year 2022. Full stop. It appears to the petitioner that since he running the business, that is distribution of food articles, food grains through electronic point of sale. Electronic point of sale ta within inverted comma মধ্যে রাখুন EPOS machine within bracket. EPOS capital E hyphen দিয়ে POS machine bracket close. Full stop. There is the allegation of the petitioner that lesser quantum of ration articles. Next part. It is the allegation of the petitioner that lesser quantum of ration articles are being provided by the authority for distribution. He filed several representations to the authority. In reply to his representation, the authority concerned had submitted a letter on 25th of October 2024, 25th of October 2024, that the deficit of his father, that is the closing balance of food grains of his father, was reckoned to be the closing balance of his FPS license. Full stop. It has also been mentioned in the said letter that petitioner himself had signed the stock position as shown by the concerned authority. The petitioner has challenged the notice on the ground that he never signed any of such on the ground that he never signed any of such stock balance sheet printed or prepared by the concerned Food and Supply Department. He lodged, full stop, he lodged a written complaint with the concerned police station regarding alleged forgery of his signature over the stock register. He made a representation to the concerned director, district distribution director. He made a representation to the concerned director, DDPNS, Food and Supply Department, Government of West Bengal. Next part. It is the case of the petitioner that due to receiving of such lesser quantum of ration articles, it is quite difficult for him to distribute the food grains properly to the beneficiaries. He prayed for necessary direction upon the authority. Mr. Sumon Senkutto, learned counsel appearing on behalf of the petitioner, submits that on the identical issue, this court has directed the concerned district controller to dispose of the matter after taking the hearing of the petitioners in WPA 26424 of 2024. First off, he submits that a similar direction may be passed. Having heard the learned counsel for the parties, it appears that the dispute regarding the closing balance appearing in the EPOS machine and physical distribution of the food grains from distributor to the EPOS machine and the physical distribution of food grains from the distributor to the dealer dealer is matter of dispute in this matter. Is bone of contention is bone of contention in this matter. Full stop. It further appears that the petitioner has also lodged a written complaint alleging forgery of his signature against the SCFS concern. SCFS concern. Full stop. Subdivisional Food and Supply, SCFS. Having heard the submission of the parties, it appears to me that the representation of the petitioner dated 9th of December 2024 appearing in annexure P10 of the writ petition required to be decided by the concerned director. Full stop.
Your Lordship, the director is only director for DDPNS. Okay.
DDPNS, being respondent number 3.
Being respondent number 3.
Okay. Under the above observation, the instant writ petition is disposed of, directing the director DDPNS, Food and Supply Department, being respondent number 3 of this writ petition, to dispose of the representation of the petitioner dated 9th of December 2024, within bracket being annexed P 10 of the writ petition, brackets close, within 6 weeks from the date of receiving of this order. Full stop. In disposing the order action by giving an appropriate opportunity of being heard to the petitioner. The decision of the authority shall be intimated to the petitioner within 2 weeks thereafter. Within 2 weeks thereafter. Full stop. Till then, the authority is directed to supply the sufficient quantity of ration articles to the petitioner so that the end users stroke beneficiaries may not be so that the interest of the end users stroke beneficiaries may not be hampered.
Your Lordship, not to deduct. In terms of prayer F, page 19. Page 19, prayer F. An order to issue restraining the respondent authorities from deducting quantum of ration article. I am led by Mr. Shah. Prayer F, that is page 19.
Prayer F.
F. An order to issue restraining the respondents authorities from deducting quantum of ration articles from the actual quantum of ration articles to the account of the petitioner on and from February 22. January already clear.
Till then, authority is directed
not to deduct any ration articles from the actual allotment.
Interest of the end users stroke beneficiaries may not be hampered. এটা বলছি তো may not be hampered. না তার আবার বলুন। হ্যাঁ না till না কারণ till then the author till then there shall be an order of to maintain supply of sufficient food grains required food grains in favor of the petitioner in terms of prayer F of the report.
I'm getting much of this.
Prayer F of the writ petition.
I'm getting
F small f. Bracket মধ্যে থাকে small f.
I'm getting
Action court. I make it clear that this court has not entered into the merit of this matter. This court has not entered into the merit of this matter. The respondent number 3 is that leave to decide all the issues raised in the representation according to the law without being influenced by any direction passed by this court in the writ petition. As affidavits are not exchanged, the allegation made in the writ petition shall be deemed to have been not admitted.
I'm getting much of it.
Deemed to have been not admitted. State के दिए रहा Next.
29, my lord. Both party present, my lord, kindly make it not today.
I appeal on behalf of the state, your lordship.
Not today.
Not today.
Very well.
Only accommodation for the day.
Next.
30, my lord.
Great, my lord.
I'm the petitioner, my lord. This is in regard to challenging of a
Praying for not today.
You are?
I'm for the state, Your Lordship. I'm led by Mr. Shumon Sengupta.
The matter?
The only thing is that the private respondent has been appointed as a FPS dealer, although there are relatives of his who are already FPS dealers. I have all the papers, my lord. I know that there's a stay by the division bench, but probably this appointment itself is wrong, which has to be set aside.
Why?
But
Relatives are there.
relatives are there. The
Which
notification,
relative?
my lord.
What is the relation?
My lord, I'm told that his sister and his brothers are already FPS dealers.
Sister and brother
My
are
lord.
FPS dealers.
My lord. And he has also been appointed as a FPS dealer, and for
Have
which.
you stated in the writ petition?
But I just got these papers. I have to file a
Have
supplementary.
you stated in the writ petition?
No,
that
I have to take out a supplementary affidavit for this, my lord.
Not this week.
The leave may be granted for the supplementary.
No,
affidavit.
no, not this week.
But the only leave, my lord. Otherwise, I got the papers after I filed the writ petition, for which I could not.
Learned counsel for the state is not there. I shall hear it out. Thereafter, I will take up that. I can give you the chance to file.
Only to bring this on record, nothing else.
No,
They can reply.
In absence of the learned counsel, it is not possible. Come on next week.
This is a similar matter, but the allegation. Yes, I'm sorry. 30.
Well, in this matter, the father of the petitioner was the FPS dealer. In fact, he was not the direct FPS dealer. The FPS dealership was granted to a cooperative society, SKUS. But the father of the petitioner was the secretary of the SKUS dealer. And when 2003 control order came into force, the new license was granted in 2006 as the proprietor. The father was named as the proprietor of the petitioner. Then
Proprietor of the FPS business.
FPS. Then, my lord, in 2009, the father of the petitioner expired. After expiring, he applied for appointment on compulsory ground, but that was not granted. And subsequently, in 2019, at the instance of the instruction given by the Scheduled Caste and Tribe Commission, they informed that the SKUS went on liquidation long back. So it is not possible to grant a license on compulsory ground. However, you can apply afresh when the vacancy will be noted. I applied
2014.
2014.
14.
14.
Okay.
I applied against that vacancy. Then but I was not given any reason to why my application has not been considered. A revacancy was made in 2020. Then the pandemic outbreak that was cancelled. In 2021, it was again notified. I applied again. In 2022, in July 2022, they again notified the vacancy. Again, only vacancy after vacancy. And I have applied against all the notification. In terms of all the notification, I have filed my application. But they have not considered that application which was made against 22 notification is still pending. I have made a several representation. Let them say what is the impediment against grant of license to me, particularly when the
appear before this court. What is your ground?
My lord,
What do you want?
I want the consideration of my application. The application has been.
What is the last notification? Page.
2022, my lord. 7/7/2022, page 37.
Okay, this is the last notification.
This is the last one.
This is the last.
This is the last.
You applied for it.
I applied. My application is
decision.
at page 40.
No decision till today.
No. Even the inspector.
Whether they rejected your application?
No, my lord. My lord, inspection has been made long ago.
Inspection made.
In fact, the dealership is running from my premises, from the old shop. Since the tag dealer has no special
vast area to run the dealership. So dealership is being run from my premises, from my old shop that was owned by my late father.
Where is your last representation?
My last representation is at
Page 45, page 41 or 50.
50.
Page 50, my lord.
page 50.
16th August 2024.
You take a decision.
That's
My lord, what we have come to know that they are planning again for declaration of vacancy without giving any reason for declaration of vacancy after vacancies.
Father of the petitioner, let Dulal Chandra Mondal watch an FPS dealer who expired on 2nd of September 2009. Since then, 2009 full stop. The petitioner applied for the license on compassionate appointment. Applied for the license on compassionate ground. His prayer was turned down. Full stop. It is the case of the petitioner that since then, the authority concerned has issued new FPS vacancy notification time and again.
my lord, is perhaps is applied for the phase one, my lord.
Yes, fresh.
Yeah.
Time and again for fresh vacancy.
Yes.
Fresh vacancy. Fresh resultant vacancy.
Resultant vacancy, my lord.
Fresh resultant vacancy.
Vacancy.
Full stop. It is the case of the petitioner that lastly on July 7, 2022, the authority has issued a notification wide memo number 125 stroke SC stroke FSDRP 2022. Petitioner applied for the license by filing
725
format by filing application. Full stop. The proposed shop come go down of the petitioner was inspected, but no result. Shop come go down of the petitioner was inspected.
my lord, perhaps memo 725, my lord.
725 I said.
Oh, great. Sorry, my lord.
725 বলেছি তো 725 বলেছি তো ওই আগে ওই পেজ ওই বলেছি তাই মেমো নাম্বার না 725 725 ঠিক করে
Grateful, my lord.
725 was inspected. Since then, no result of such vacancy notification was taken by the authority. The petitioner approached the authority via a notification, via a representation dated 16th of August 2024. Authorities had not responded. Hence this writ. Having heard the learned counsel for the parties, it appears that the authority concerned must have passed a reasoned decision in terms of the representation of the petitioner dated 16th of August 2020. Full stop. Under the above observation, the instant writ petition is disposed of. Concerned subdivision controller being
Respondent number 3, my lord.
3 of this writ petition is directed. 3 of the instant writ petition is directed to take a reasoned decision in response to the representation of the petitioner dated 16/8/2024 within 6 weeks. In respect of his representation dated representation dated 16th August 2024 within 6 weeks from the date of communication of this order after giving a reasonable opportunity of being heard to the petitioner. Full stop. The SCFS concerned shall take the regent decision in terms of the representation as well as the fate of the impugned memo dated 7/7/2022 and shall intimate the same to the petitioner within 2 weeks thereafter. Okay. That is not a, I have not completed yet.
No new vacancy.
What are you doing? Now 1321. You want me to sit here? Okay. I make it clear that this court has not entered into the merit of this matter. This court has not entered into the merit of this matter. The respondent number 3 is at leave to dispose of the matter according to the law without being influenced by the
Grateful, my lord.
being influenced by the any order passed by this court. Full stop. Next paragraph is same given. As the affidavits are not exchanged, the allegation made in the petition by the petitioner shall be deemed to have been not admitted. Shall be deemed to have been not admitted.
Grateful, my lord. Grateful.
My lord, meanwhile, no notification should be made again.
No. Let them take a decision.
Lords. Grateful.
Number 30. I'll make it more. After 2, I have some.
Not today.
33.
Okay. PMA? Huh.
Mr. Agarwal has not come to court, Malad. I am praying, well, can it be adjourned to another date, Malad, subject to convenience of my learned senior, Malad? He has some personal difficulty.
It has not started yet.
Yes.
My lord, Mr.
yes.
Agarwal has concluded, my lord. I have commenced my argument on the previous occasion, my lord. I have submitted facts have been placed, my lord. A little bit is still I have to make submissions. So far fact is concerned, then I will rely upon some case laws.
Yes, you have started your
lord.
argument on the last day.
My lord.
Since there are some personal difficulties, Malad, I was praying for it. Subject to lordship's convenience. If your lordship grants, Malad, any day after 6th will, Malad.
So what is your instruction? I want
Seek
to
for
know
an adjournment, Malad.
whether we can start today or we can.
If he,
I can start, my lord. He can take notes, my lord, so that.
Now, what is your
yes, I
instruction?
can do so, but problem is, Malad, if he would have been there, we could have
Very well,
replied
very
to
well.
as well.
Instruction is otherwise. Very well. Tomorrow?
Malad, after 6th, any day, if your lordship.
After 6th, not this week.
6th.
6th means 6th is the Thursday.
No calendar.
10th. 10th is the day. 10th কি আছে? বিশ্বনাথ?
No, so 2 p.m.
10th, 2 p.m.
I'm grateful to your
I'll
lordship.
let it retain its position because the first matter is
Yes,
taken.
first matter.
I'm grateful to your lordship.
Please take down. On the prayer of the learned counsel for the petitioner, the matter be adjourned to release the matter on 10th of February at 2 p.m. Thank you.
May I start?
Yes.
I have almost concluded, my lord. All the three repetitions are.
Mr. Sara is appearing. Item number 50.
Antara, Gargi and Nomita.
Yes, my lord. The three repetitions, the contents, facts are almost same. Now, on the last occasion, I indicated that the locations were different. One is Uchildaho, which was mentioned in the application, whereas the advertised location was Atpu. And in view of the same, the alternative land was considered, FBC was conducted, and it was found to be satisfactory or satisfied the eligibility criteria. Now, what the eligibility criteria I have already mentioned. And in view of the same, letter of intent was issued. The letter of intent specifically provides that he will have to comply with the requirements for setting up the, for commissioning of the distributorship within a specific period.
So lastly, you have argued the alternate land, though may be the same land, but documentation is not same.
My lord, how do I identify the location? Basically, it's a revenue village. That is the advertisement. There has to be in a revenue village. Revenue village, it was Uchildaho. It was mentioned. Whereas the advertised location is Atpuku. So prima facie, it is outside the consideration. Without going into detail of the physical verification of the land, it is outside. Since physically may be same, but the locations are different. That's why it was considered to be an alternative land. Moreover, this is one aspect of the matter. Second aspect, that it was already the policy guideline was also already in vogue, which gives him the opportunity to offer an alternative land at FBC stage. So he was given an opportunity to offer the alternative land, and that land was offered. And as a matter of fact, the lease deed or the deed relied upon by the successful candidate in his application, the topshil or the schedule mentioned it as Atpuku. However, he incorporated the same as Uchildaho.
In the application.
In the application.
Erroneously, it was mentioned as Uchillo.
In view of the same, it was considered. Now, the basic requirement to see is whether by giving appointment, whether we have waived or relaxed the specific eligibility criteria or essential eligibility criteria. We deviated. That is, on the face of the record, a person who is not qualified was allowed to get the distributorship. First, whether the land was within the location of specific dimension, etc. at the verification stage.
Okay.
Whether it is a water body, had it been recorded in the revenue records, the thing would have been different. Since it was recorded as agricultural land, Bilan agricultural land, which is convertible, therefore it was considered. These are the requirements on the basis of which letter of intent was issued. Now, letter of intent is page 65 of my affidavit in opposition.
Yes.
Now, last but one paragraph specifically says, page 65, Amar affidavit in opposition. Last but one paragraph, page 65, you should have to ensure that an all-weather motorable approach road, public or private road connecting to the public road of the minimum 2.5 meter width is made available within a period of 4 months from the date of this letter in order to provide access of LPG cylinder truck to the offered land for godown and LPG godown. In case of, it is important here that truck should move on and from godown.
You are reading page 65.
65, last but one paragraph.
You should have to ensure that.
Yes. The approach road should be verified for its suitability. The next paragraph.
Yes.
The approach road should be verified for its suitability before the issuance of letter of appointment. That is the last stage. So why I indicate that to show that at the field verification stage, the approach road was not essential. It has to be after the issuance of the LOI. Now, your lordship turns to page 70, my lord.
Yes.
This is the letter after receiving the LOI. He offered to another land, alternative land, my lord. I have indicated that two options are there. During field verification, he can offer alternative land as well as LOI stage. And the undertaking, as indicated by Mr. Shahara, was in general in nature. That does not preclude him or any candidate from taking advantage of the alternative land as given under post LOI stage. Since several points are involved, I will submit a written notes of argument, my lord, to refresh, my lord. Now, this particular page, this letter indicates, with due respect, I would like to express that.
This is region order page 79.
No, 79 I will come. This is 70.
70.
70.
70, yes.
This is the letter written by Indumati Raut, that is the private respondent. With due respect, I would like to express that I want to change the plots of land for showroom and godown, and these plots of lands are very low lands.
Yes.
I pause here for a moment, my lord. Here, the word very low lands have been used. Now, it has been indicated on several occasions by the petitioners that lowlands have been omitted, have been deleted to contend that it is a very land.
Yes.
In the writ petition, I will indicate writ petition.
They have all along said it is a very land.
No.
And it is being
What I-
used as a very pisciculture.
At writ petition page 56, my lord. Why I show this? Scrupulously, the very low, the word low has been deleted. This is the actual letter in my affidavit in opposition. However, in the writ petition, page 56, your lordship will see.
Okay, the copy of that letter.
Yes, but your lordship sees these plots of lands are very lands. The law has been omitted, deleted for the purpose of the writ petition. I will not argue on this point, my lord. This has been stated. In any event, that cannot improve their case. তোমারই রিট না না অন্তরা আচ্ছা সব কটাতেই এই করেছে লোটাকে মুছে দেওয়া হয়েছে anyway this was the alternative plot of land given at the LOI stage.
Yes.
Thereafter your lordship comes to page 72 where the alternative plot of land was considered by the authority. In this, may I place, this is a note sheet for approval of alternate land after issuance of the LOI.
Yes.
Note sheet says, in this regard, he has submitted an application addressed to such and such, dated such. During FVC, the nominated committee had inspected the godown land against the LOI had been issued to the selected candidate with the following details. This describes the initial land on the basis of which LOI was issued. That is godown land, LR 1612, LR Khatiyan number such, Mouja Uchildaho, District 24 Parganas. Showroom, plot number 1620, Khatiyan number such, jail number such, Mouja 8 Kukur.
That is the previous land.
This was the land on the basis of which
LOI was issued. Yes.
Thereafter, it has been specifically mentioned. The next bullet, the alternate land details submitted after issuance of the LOI. Here describes the after LOI.
Yes.
The godown lease deed such and such 2019. Now, a question may crop up that may be asked that the eligibility criteria provides that your land should be before the last date of the application. But as I have indicated in the last occasion also, this particular clause does not apply post LOI, since it says that even a new land can be given. May I indicate the again the relevant portion of the brochure?
I cannot follow.
In the
After LOI,
he can offer a new land also.
land.
Yes.
Which was not owned by him.
No, not owned, not owned, which has been registered subsequent to the last date of application.
Okay.
May I just to refresh?
Show me the brochure.
My lord, it will be from 2B, that is at page,
Page 31.
Yes. If the land, 2B, if the land offered by the candidate in the application or alternate land offered by the candidate at the time of field verification. So covers both original in the application and alternative land during FVC meets all specifications as laid down in the advertisement on the basis of which LOI has been issued, then the LOI holder can offer an alternate new land for construction of godown specified dimensions in the advertised location. Now, it does not stop with alternative land. FVC stands alternative land, but here a specific word new land has been incorporated. for construction of godown of specified dimensions in the advertised location, which will be considered on the grounds of enhanced security, safety, better title, convenience, etc. The selected candidate has to ensure that an all-weather motorable road of minimum 2.5 meter width is made available to provide access of LPG cylinder truck to the offered land. At FVC stage, a distinguish has to be made.
So your submission is that this is the only clause?
Here, during FVC stage, an alternative land has to comply with the eligibility requirement so far as registration prior to the date of the last date of the application. However, post LOI, it's a new land. Why I tell you, Your Lordship? Your Lordship compares this clause with the clause at page 38. Yes, my lord. To distinguish that LOI stage, a new land can be given which need not be registered prior to the last date. Whereas at FVC stage, it is compulsory to get it registered prior to the last date. Here it is stage, this is FVC stage. Opportunity to offer godown and showroom. In case if the offered land for godown and offered land for showroom by the selected candidate, which is shown in the application, is found not meeting the eligibility conditions, requirements as stipulated in the advertisement brochure application at the verification stage, then the selected candidate can offer an alternative land which is owned by such and such family.
Everything is there.
As on the last date of submission of the application.
As on the last day of submission of application.
So this is the FVC stage, clearly mentions on the last date of application.
Yes.
So FVC stage, alternative land, comply with the last date of submission of the application.
So you are saying this provision is in respect of only FVC stage.
FVC stage.
Not beyond that.
Yes. The moment FVC stage fulfills LOI is issued, he can offer a new land in terms of clause 2B.
Clause 2.
2B.
That is the new land.
Yes.
But new land has not specified that it should be within the date. It should be owned within the date of the last date of submission.
That I am indicating that new land post LOI, after LOI, new land need not be registered prior to the date of the last date of application. Whereas in FVC stage, he have to be get it registered prior to the last date.
I understand the FVC stage it was sufficiently mentioned that it should be within the last date of submission of application.
Yes.
But there is no such mentioning like that after LOI.
No such mentioning. New land indicates, new land is indicated in LOI stage. In FVC stage, the word new land was not mentioned for the same reason.
So you are saying the new land means the land which not required to
be
registered or owned within the date of the last date of application.
Yes.
Is there any authority on the point?
Yes, I will.
Okay.
Not authority, but division bench of this court.
Okay. Yes, yes.
unless challenged or set aside, that becomes an authority.
No, the next paragraph of page 38 make it clear that who has been issued an LOI, the specification has to be there.
Which one? Selected candidate who has been issued LOI.
Yes.
Can offer an alternative land which is owned by the applicant family unit. Obviously.
Everything
is there. Look at
in the advertised location, last two
provided
lines.
the land originally offered in the application was meeting all specifications as laid down in the advertisement on the basis of LOI was issued.
Yes. So it is said the specification has to be same. What does it mean? The next paragraph. In the advertised location, provided the land originally offered in the application was meeting all the specification as laid down in the advertisement, and on the basis of which LOI is issued.
Yes. Your lordship probably is thinking that originally offered land means the
before the LOI.
LOI.
Yes.
So that met the requirement for which the LOI was issued. So unless it meets the requirement or satisfies the conditions, LOI cannot be issued.
Yes, LOI was issued. That is for we have take the task page 38 first paragraph. That is before the LOI, and second paragraph is after LOI.
The second paragraph, this portion has to be read with to be.
That is, you are saying the new land.
New land.
The new land should have within the specifications as laid down in the original advertisement.
No,
on the basis
new
of
land, new land need not be of earlier date. That is my submission, my lord.
Okay. Okay. Yeah, I understand your submission. You just satisfy me on that point.
Yes, I will with the
yes
division. Now, I placed page 72, on the basis of which
page 72.
72, the offered land, 72, again, the offered land is duly verified by, last but one paragraph, 72.
Yes.
The offered land is duly verified for construction of godown in terms of general suitability criteria as mentioned in Unified Selection Guideline distributorship. It is also to be considered that showroom land and godown land is situated on the two banks of the same river, and distance between the two land is about 1 kilometer. Moreover, the godown land has better road connectivity for transportation of cylinders. In view of the above, DGM Kolkata area office is requested to record this kind of approval for construction of the godown in the above alternative land. This was the finding, and on the basis of which post LOI alternative land was accepted. Now thereafter, in the second writ petition, Namita Mondol's matter, an order was passed for considering his representation and the writ petition. Her representation rather. That is starts from page 73. This is the reasoned order of my affidavit in opposition.
Yes.
This is in compliance of the order dated 24/12/20 passed in such and such. Personal hearing was given on 29/12/20 and background was recorded. I need not travel into all these matters.
Yes.
But in page 75, the allegations by the writ petitioner Namita Mondol in the tabular form written in the left side, and observations of the committee was recorded in the other side,
Yes.
in the right hand column. Now, from serial number 2, page 75, that on 15/11/2018, it was the allegation. By making a representation, the said Srimati Indumuti Raut submitted the documents of the self-same land as alternative land in terms of the letter dated 30/10/2018 as one-time option. It is needless to mention that the candidature of Srimati Indumuti Raut was rejected on the ground of said land on 6/9/2018. It is needless to mention that the said representation was made without depositing fees and the same was accepted by IOCL. Now, in answer to that right-hand portion, although the policy for offering alternative land was already in vogue, however, in the instant case, the candidature was cancelled on the ground of misrepresentation of facts. However, her candidature was accepted as per the direction of the Honorable Court by such and such writ. Though the policy of alternative land was applicable, here land was physically available in the required location. However, addressing was incorrect, hence it was considered as misrepresentation of facts. Next, page 3. Indumoti Raut has obtained the said letter of intent by suppression of real facts, as because there is no road in respect of her offered land for showroom and godown to provide access of consumers to the showroom and also access of LPG cylinder truck to the offered land for godown. As such, the said letter of intent was issued in her favor without any field verification at all as per guidelines. Observations: the allegation is not established in view of the following. For issuance of LOI, there is no need for existence of road in respect of godown and showroom at the time of FVC. At the time of acceptance of LOI, LOI holder has to provide an undertaking that the approach road as specified will be provided within the time frame, which will be duly verified by IOCL official before issuance of LOA. In this regard, reliance may be placed on Clause 8 of the Unified Guidelines for selection of the distributorship. Now, Clause 6, item serial number 6 as page 77.
Yes.
As because the authority of IOCL has given a chance to the said Srimati Indumuti Raut to offer the land as alternative land by exercising one-time option which she belonged to, the last date for submission of application. But here the land approved by the competent authority which the said Srimati Indumuti Raut took by way of lease on 3/7/2019, that is much after the date of issuance of the letter of intent. Therefore, it is obvious that the Srimati Indumuti Raut has no land at the time of application and or at the time of issuance of the letter of intent, which meet the eligibility conditions as per advertisement as well as guidelines. Therefore, her candidature is liable to be rejected. This is the point which your lordship just asked me. The allegations are not substantiated in view of the following. As stated in point 4 above, LOI holder can offer alternate / new land as per Unified Guidelines for selection of LPG distributorships, Clause 2. Basic facilities required for operation of LPG distributorship under B and E, relevant portion of which is reproduced below. Now, the Clause 2B has been reproduced.
Yes.
2E has been reproduced, my lord. The same thing I have indicated. Now, next, Clause 7. The said leasehold land is situated beyond 15 kilometers from the advertised location. On that ground, her candidature is liable to be cancelled as per guidelines. The allegation with regard to distance is not substantiated in view of the following. Showroom of the LOI holder is at Atpukur, which is in the advertised location. The same was verified by the competent official of IOCL. Godown of LOI holder Srimati Indumati Raut is within 2 kilometers distance from the advertised location. Clause number 8.1 of Unified Guidelines for LPG distributorships in this regard. For Gramin Vitarak, the candidate should own such and such. Now, pausing here for a moment, my lord, the public at large is required to visit the showroom, not the godown. Godown where we should have a motorable access road for delivery of the cylinders. In the instant case, the showroom and godown are within 1 kilometer, but in between there is a river and there is also a bridge. But a truck need not travel from godown to showroom or showroom to godown. Truck is required to come in the showdown, and people are required to visit the showroom only. So there is no justification in showing the Google map of having the wide road, since people will not travel from showroom to godown for cylinders. Cylinders are to be delivered by the oil company, distributor of the oil company, to the residents, and the peoples need not travel from showroom to godown. So it is within, and that is, the map is included in the affidavit in opposition of the private respondent. I will show that. Obviously, they will also show.
No, the question is whether it is situated beyond the 15 kilometer for the average location.
No.
So
In
whether
the event metal road is required, it is not specified in the advertisement or the brochure that there should be a metal road or motorable road from approach road from showroom to godown. Godown will have an approach road. That godown and showroom need not be connected by a motorable approach road. That can be connected. Moreover, this is public interest and publics are involved, and the showroom is to be visited by the public at large. Godown is not required to be visited by the public. So distance is immaterial. It is within
you have
within
to
15 kilometers.
supply the said article, that is the cylinder, from the godown.
Yes.
So
There is a road in the godown connecting the godown. There is a road. I will show the photograph that is been annexed with the affidavit in opposition of the private respondents. There is a photographs, showroom. All the things are completed and constructed and fully verified.
Okay.
There is a road, approach road in the godown. There is a road in front of the showroom also for the public at large. And the showroom and godown is within 15 kilometers. That is also in the sketch map. In view of the same, this representation of Namita Mondal was rejected as per observations. That is as page 80 onwards. All the points have been clearly dealt with.
Here your answer is within 2 kilometers from the central location.
Yes. My lord, just pause here for a moment. This was the affidavit in opposition of, they will place obviously. This is the affidavit in opposition of the private respondent, that is the successful candidate. The voluminous one may be there.
যেটা মোটাটা সেটা দিন।
Now, last but one page, last two pages, that is 438 and 439.
Yes.
In the middle, it is Vidyadhari Nodi. It has been written in Bengali, Vidyadhari Nodi. Now, at the bottom, your lordship will find LPG gas godown.
Yes.
And straight coming forward, thereafter at the top, LPG gas office.
Okay.
And there is indicated, your lordship will see that godown is attached with গাড়ি চলাচল এর বামনপুকুরের মাঝে পাড়া ফেরিঘাট রোড, মোটরেবল অ্যাপ্রোচ রোড কানেক্টিং কলকাতা বাসন্তী হাইওয়ে. And the distance has been clearly mentioned. May I read it in Bengali? বর্তমান পজিশন অনুযায়ী এলপিজি গ্যাস গোডাউন হইতে এলপিজি গ্যাস অফিসের মোট দূরত্ব 1915 ফুট প্লাস নদী 840 ফুট প্লাস আটপুকুর 1410 ফুট. It means 3805 ফুট, nearly 1.159 kilometer. Now, has been indicated that ferry cholachol has been indicated. Now, persons or the LPG truck is not required to travel from LPG gas office to LPG godown or LPG godown to gas office. People can visit LPG gas godown is having a motorable approach road and LPG office also having an approach road. The distance is within 1 kilometer. And now by Google Map, they intends to clarify that there is no road in between, but that is not required. Since what is the eligibility conditions? Eligibility that the gas godown should have a motorable approach road for delivery of the filled cylinders and for taking away empty cylinders. That is having that approach road. So, and that should be within 1 kilometer from the godown, from the showroom or within the advertised location, 15 kilometer from the advertised location.
So it is not required that the godown should be within the vacancy notification.
Yes,
Vacancy
yes.
location.
No, not in Atpukur, the advertised location, within 15 kilometers from the advertised location. That has been specified in the brochure.
Within 15 kilometer from the
advertised location.
Advertised location. Now, whether within 15 kilometer there is a air distance.
No. Your lordship kindly comes to page 35 of the affidavit in opposition.
Your affidavit in opposition?
Yes. Page 35.
Yes.
Clause M mentions go down, and for location in states, union territories except Kerala state, it states Gramin Vitarak, the candidate should own a plot of land of minimum dimensions 21 meter into 26 meter within 15 kilometer from the advertised location. Nowhere it states that there should be a motorable approach road or approach road in between godown and showroom. That has to be within 15 kilometer from the advertised location. Advertised location is Atpukur. So that should be within 15 kilometers. That need not be within the same revenue village. That is the advertised location Atpukur.
Now, I want to know whether the 15 kilometer is the road distance or air distance.
Even if it is a road distance, there is a road. It does not specify motorable approach road. It is not required also. So for all practical purposes, godown and showroom or the advertised location and the godown, there may be a road or may not be a road. That should be within the 15 kilometers of the advertised location, having an approach road, motorable approach road for delivery of the cylinder. For the purpose, it has to be taken into consideration for what purpose it is written, that motorable approach road. For delivery of filled cylinders and for taking back the empty cylinders. But in between, what they have indicated that godown and showroom should be have a motorable approach road, or that is within the advertised location, 15 kilometers within, and for which they have placed, that is the Google map. And that shows the road distance, metal road distance. For what purpose? কত কথায় দিয়েছিস বলতো এটা? I'm showing, my lord. They have placed one Google map, my lord, to indicate that that is beyond 15 kilometers. Right now. Page 65, my lord.
Read petition.
Yes. The motorable approach road. The Google map indicates that has to be a road to indicate that that is beyond 15 kilometers. But that is not the purpose of the brochure.
Okay.
My lord, I have already placed 2 or 3 judgments, my lord, but this is the division bench of the Honorable Bombay High Court, and has also been not been set aside by the Supreme Court. You need not travel into the entire thing. Why I indicate that all the judgments regarding the tender, arbitrariness, malafide, etc., has been dealt with in this writ petition, in this order, starting from, and what I have also indicated, starting from paragraph 27, that is internal page 20. Paragraph 27.
Yes.
Yes, I have referred to Cato. I have referred to other judgments also, if required, and have decision with reason starts from paragraph 29. I need not travel into all these judgments. That is Jagadish Mandal I have relied upon, or I will also place the same again. AFCON's judgment infrastructure has been dealt with. And after dealing with all the relevant judgments, why I place this, since the relevant portion of the judgments have been referred to. By going through this judgment, your lordship will be able to just have a complete view of the position as on date regarding tender matters. Now, observation starts from paragraph 43 at page 29. 43 and 44, 43. 43 will be will clarify the entire thing.
Yes.
Our law, our understanding of the law, drawing guidance from the decisions noticed above, is that the terms and conditions of a tender are not to be read and interpreted in the same manner a statute is read and interpreted. The legislatures make laws actuated with some policy to curb public evil or to effectuate public good, as and when an issue arises before them. It is the duty of the constitutional courts to interpret the law and declare what the law is. If the courts find gaps in the working of the law while interpreting and declaring what the law is, it is not precluded from ironing out the creases by appropriate technique of interpretation to infuse life into the law. But it is impermissible for the courts to alter the material of which the law is woven. Such ironing out of the creases inter alia is generally premised on the court's perception of what the legislative intent was. In doing so, the courts are entitled to interpret and declare the law without consulting the legislature to explain what was intended while enacting the law. Legislative functions come to an end once the law is passed. When the constitutionality of a law is challenged or when the court is otherwise required to interpret and declare what the law is, the parties opposing, supporting the law are only heard. However, in regard to interpretation of tender terms and conditions, starts from here.
Yes.
However, in regard to interpretation of tender terms and conditions, the perspective is completely different, and such an exercise as can be taken recourse to in interpreting a statute would be impermissible. Terms and conditions in a tender are set which would advance the tendering authority's interest. When the terms and conditions of a tender fall for consideration and the need arises for the court to understand what is meant by a particular clause or what is requirement of a particular clause in such tender, the tendering authority's version has to be heard by the court. If such version of what it intended by inserting the relevant clause appears to the court not to be manifestly unfair, utterly unreasonable, totally arbitrary, or thoroughly unjust, the court cannot substitute its view of what would have been a better course for the tendering authority to follow to achieve the object of the tender. Deference to the view of the tendering authority by the courts is the general rule. The adverbs in the preceding sentence would signify a level higher than what in one's perception the requirement of a clause would amount to being seen as unfair, unreasonable, arbitrary, or unjust. When a party invokes the court's jurisdiction and claims that a clause in the tender ought to be read in the manner it reads it, in such a case, the tender terms and conditions have to be read by the court and understood in the language they are plainly expressed. Even if any particular clause is ambiguous, and upon a query being raised by the court as to what the clause precisely means or what is its requirement, the meaning that the tendering authority gives has to be accepted without reservation, unless, of course, such meaning contravenes a constitutional right. This is because of the freedom that has to be conceded to the tendering authority to choose with whom it would like to enter into a contractual relationship, and the allowance of certain measure of free play in the joints, which is necessary concomitant for an agency working in the administrative sphere as in the present case. Why I place this? To show that the interpretation given by the Indian oil authorities insofar as new land is concerned or for the requirement of road in between advertised location and the godown should be interpreted in terms the Indian Oil Corporation has interpreted, and the alternative lands. What?
Yes.
And last judgment, my lord, that is Jagdish Mondal, probably I have cited, but still এটা হচ্ছে দেখো 2007 ভলিউম 14 SCC 5 and 17. All this I will include in my written notes of argument annex.
Jagdish Mandal. Yes. Paragraph.
Paragraph 22, my lord. Although it discusses several paragraphs, I need not travel into.
Yes.
Judicial review of administrative action is intended to prevent arbitrariness, irrationality, unreasonableness, bias, and malafide. Its purpose is to check whether choice or decision is made lawfully and not to check whether choice or decision is sound. When the power of judicial review is invoked in matters relating to tenders or awards of contracts, certain special features should be borne in mind. A contract is a commercial transaction. Evaluating tenders and awarding contracts are essentially commercial functions. Principles of equity and natural justice stay at a distance. If the decision relating to award of contract is bona fide and is in public interest, courts will not, in exercise of power of judicial review, interfere, even if a procedural aberration or error in assessment or prejudice to a tenderer is made out. This is important. The power of judicial review will not be permitted to be invoked to protect private interest at the cost of public interest or to decide contractual disputes. The tenderer or contractor with a grievance can always seek damages in civil court. Attempts by unsuccessful tenderers with imaginary grievances, wounded pride, and business rivalry to make mountains out of molehills of some technical procedural violation or some prejudice to self and persuade courts to interfere by exercising power of judicial review should be resisted. Such interference, either interim or final, may hold up public works for years or delay relief and succor to thousands and millions and may increase the project cost manifold. Therefore, a court, before interfering in tender or contractual matters in exercise of power of judicial review, should pose itself the following questions: whether the process adopted or decision made by the authority is malafide or intended to favor someone, or whether the process adopted or decision made is so arbitrary and irrational the decision is such that no responsible authority acting reasonably and in accordance with relevant law would have reached. Thirdly, whether public interest is affected. Last, now we have already constructed a godown that is having a road. I will show the photographs. If the answers are negative, there should be no interference under Article 226. Cases involving blacklisting or imposition of penal consequence on tender contract, that is different. This is the thing. Now, my lord, they will indicate, my lord, private respondent, but what I have is the storm. The godown is constructed with roads, my lord. They will indicate, my lord, the private respondent.
Yes.
It is their affidavit in opposition where the pictures are there. Now, your lordship has asked me whether authority the second time at the LY stage whether it can be granted. Your lordship kindly allow me for a moment, my lord. I will hand it over to them one copy. Same as also before they start their reply. And your lordship also. That is an unfortunate judgment, that's why. Right now. That is regarding that alternative land and LOIC
Yes.
and new land.
What is the definition of new land?
Yes. That matter also, Mr. Shahara was educated. And here was when reference to আমি এই ম্যাট নাম্বারটা দিব না কপিটা এখানে আমি বের করেছিলাম হয়তো ঢোকানো হয় দিয়ে এর মধ্যে দিয়ে দেবো রিপ্লাইয়ের আগে দিয়ে দিলেই তো হবে now my lord my humble submission my lord so far as arbitrariness malafide or favoritism has not been made out in the writ petition we have acted on the basis of the guidelines and no clause relevant of the guidelines has been relaxed to accommodate the private respondent my lord. Now unless relaxation affecting the right of other general public intending candidates under Article 14 is hampered or affected, there cannot be a writ under Article 226. Had it, their contention may be that, had it been a case known to the other persons that the conditions would be relaxed, they would have applied for the same. But in the instant case, we have not relaxed any condition. First, there was misrepresentation, erroneous recording, although he was having the land within the advertised location, but erroneously written. The deed was also referred to, or the schedule of the lease deed specified it is within the zone. It was alternate opportunity to offer alternative land was within the brochure. We have not relaxed the condition to accommodate him to offer an alternative land. It is an alternative land in view of the same that the earlier land was Uchildaho and the offered land was Atkupu. Subsequently, LOI was issued. At the LOI stage, he offered to provide an alternative new land that was within the guidelines, and he was allowed to provide the same. On the basis of the same, he constructed the godown, and the same is ready for commissioning.
Yes.
These are all my submissions, my lord, with the liberty to file written notes of argument annexing all the judgments as well as the factual aspects and the relevant provisions of the guideline.
Okay.
Private respondent, I don't know whether they were appearing, my lord, I don't know. No prayer on that. I cannot make any prayer on their behalf, but they were appearing all along. No, no,
Yes, where is private respondent? Who is appearing? Fahmi Mohammed. Yes. Samrat Depal.
The last occasion he was there, but today he's not appearing.
An opportunity I will communicate, my lord. Since they have filed an evidence. আমার submission শেষ হয়ে গেছে বলো তোমাদের
Yes. For the private respondent number 9.
9, Lordship. Matter, Lordship, Mr. Shami Mohammed will argue with this matter, Lordship. Is now courtroom number 13, Lordship. I'm praying for only 2 weeks' time for prepare.
Weeks time?
2 weeks.
Why weeks
Or
time?
Or 1 week.
Running in the list. Quite long time it is running in the list as a pattern matter. We have extensively heard the matter. Your turn.
Next week, Lordship.
Next week. Next week. Only one day, Wednesday. বিশ্বনাথ আস্তে কি আছে
নেক্সট উইক
সেকেন্ড হ্যাঁ একটা আছে একটাই ম্যাটার আছে না হুম, ওইটা আছে আর কিছু পড়া হবে ওটাই argument on behalf of the Indian Oil Corporation concluded. On the prayer of the learned counsel appearing on behalf of respondent number 9, the matter be urgent today. Release the matter on 5th of February at 2 p.m.
But instead of 5th, my lord, can it be on 10th, my lord?
No, no,
My lord, on this, my lord,
Let them start.
সরস্বতী পুজোর পরের দিন ইন্ডাস্ট্রি পয়েন্ট
Call next matter. And I'm the petitioner, my lord. This is also regarding challenging of a person who has been declared a successful FPS dealer. The first ground of challenge, apart from everything else, is that this is a society. The private respondent is a society registered under the West Bengal Society Registration Act. Now, when it comes to the criteria for being selected, that is, it starts from page 18. Relevant portion is at page 19. Have you served? Right, I've served. May I file myself? Yes, sir. Will kindly come to page 18. This is the recruitment notification or the appointment notification rather. Read in the nature of co-warrant too. For removing this person. For causing the appointment of the private respondent. Whether the co-warrant is required. The other prayers are also there, my lord. Other prayers are also there. Yes, what is your case? The private respondent. I'll just show the eligibility criteria first. Thereafter, I'll come to my case. Page 18 is the notification. Page 19. Para 8, eligibility criteria. The applicant, Matt has got it? Yes. The applicant must fulfill the following eligibility criteria. The applicant must be A, an individual permanently residing in Domkal subdivision. This is a registered society under the Societies Act, not under the Cooperative Societies Act. So A is not satisfied. B is registered partnership firm, not satisfied. Registered cooperative society, again not satisfied. Shango or Mahashango or self-help group, not satisfied. Within Murshidabad district, not satisfied. 3 is individual applicants or partners of a registered partnership firm, or members of a registered cooperative society, or members of a Shango or Mahashango or self-help group applying for FPS dealership must be adult Indian citizen. Nothing has been satisfied.
So who is the private respondent?
Private respondent, my lord, will kindly come to page 2. Respondent number 5 is a registered society under the West Bengal Society Registration Act 1961, not under the West Bengal Cooperative Society Act. So initially, this person does not even have the eligibility to apply for this post. He could not have been selected. It will, if my lord turns over to page 69, he has been declared as the.
No, where is the document regarding the private respondent number 5?
Respondent number 5, I have already applied to for a certified.
Why you are saying that he is not a partnership firm?
Because I have specific information that he is a society under the West Bengal Registration Act 1961.
So where is the document?
The document it is not readily available. I have applied for.
So you have challenged. What is the ground you challenge?
Not only this. This is not the only ground, but this is one of the primary ground, but not only this. My lord will kindly see the result of this. This is at page 69. No reasons given, no panel disclosed, nothing. Just one name, he has been selected, nothing else. This is all that the website says. This person has been selected. So there, in my humble submissions, my lord, whenever there is a selection process and whenever there are multiple tenderers for the particular post, a panel has to be created. There has to be a basis on which one is.
Who are you?
I am also an applicant.
Applicant, when you applied?
My lord, there are 2 petitions, both have applied. My lord, the first application is at page 22. In respect of the petition number 1, it is at page 22. The receipt is here. And in respect, both the petitioners have all the eligibility criteria. I can show from the documents, all are annexed.
Yes, show me.
Yes. And
this is the dealership or distribution?
My lord, this is the dealership.
Dealership.
My lord, will kindly turn over to the circular. I will just show one by one what I have. Firstly, I am an individual. It's Preeti Lata Sarkar. It's an individual, so I get into 8 Roman 1. I'm an individual permanently residing in Domkol subdivision. I have annexed my address proof as well. Electricity bill is also there. Second is, for panchayat area, it must be a space of minimum 300 square feet along with covered space of 100 square feet adjacent to the godown to be used for office space for weighing and post operation. Total number of compartments for shop and godown should not exceed 3 and should be adjacent, connected to each other. However, if the godown and shop are accommodated in a single compartment, then the area must be minimum of 400 square feet. So I also get into this. My lord will kindly turn to page 24. This is the plan of my shop room.
Yes.
Godown area is 817 square feet, much more than the required ones. Office is 208 square feet. Existing shed cover where the people needs to have to wait in a queue for collecting. That is 194 square feet, much more. The total area is 1219 square feet when the minimum eligibility is 400 square feet in total. 300, 100, 400 square feet, and my area is 1219 square feet. Now, I do not have the details of the private respondent, but if my area is more than that of the private respondent, and if the private respondent has been selected even thereafter, then probably the selection process has to be reviewed by this honorable court. Page 25 is the rent agreement for this particular space. I've also given pictures of this particular space, page 29. This is a picture of this particular space along with the petitioner standing therein. I've given the electricity bill of this particular space, that is at page 30. And there is a provision that my bank account has to have at least 50,000 rupees. So I have disclosed my bank account statement as well. That is at page 31. I'll just show the clause. Page 19, this is Roman 7, working capital or fund required at the time of application. Applicants for dealer must have a bank balance of 50,000. 50,000 is also satisfied. That is at page 31. In fact, my balance is 104,304, double than that, double than the required amount. I have that in my bank account. Yes, what you want now? Now, my lord, at least the state is not here. At least a report from the state, and this where the state should disclose the panel, the entire panel where who has been appointed and why he has been appointed. And in regard, there is also a division bench judgment which has effectively stayed appointment. So that should I can show similar documents of the petitioner number 2 as well. The petitioner number 2 is also an applicant. Yes. If my lord wants, I can show the documents of the petitioner number 2 as well. If my lord deems fit, I'll show every document of the petitioner number 2 as well. And in respect of the petitioner number 1, there was inspection as well. That is at page 45. There was inspection as well, but no copy, no order copy. That what is the result of the inspection? What happened thereafter? Nothing. The only thing since it's already my lord knows that it is already stayed by an order of division bench every appointment. I'll just hand over a copy of the every appointment. My lord, may I hand over a copy of the division bench order? 1543. 1543. No, that is not every appointment. That is not every appointment. Maybe I have. No. May I just
That
hand
is
over?
separate issue. I know that order.
My lord, then I'll not rely on this. But probably this is a issue where firstly the private respondent may not be eligible at all. Secondly, if I make an application, I have all the eligibility criteria. I should be at least I should know why I have not been appointed. Have you made any query with the authority? My lord, I have. Where is the representation? Representation, my lord. My lord will kindly give me a minute. Oh, 68, my lord. Page 68, my lord will kindly come to. That is minister in charge. That my lord, my client, it should have been to the department. My client may not have known the law properly. Minister in charge should not be there, but then what minister in charge shall do this matter? It will be forwarded to the secretary that is there, but this was the representation which was there. That is there. I cannot justify this, but these are my client is not. You have not approached the authority. Now you have approached the minister in charge, who is not the authority. That my client, my lord, knows that these people do not know law. These people know the law more than you and me. That is not the question. Very well. So please take down. Only thing, at least the state report should at least disclose all these things. Very well. Petitioner challenge the appointment of FPS license in favor of private respondent number 5. Full stop. It is the sole it is one of the ground for the challenge that private respondent is a registered society under the West Bengal Society Registration Act. So the private respondent cannot become under the definition of eligible candidate. Eligible candidate stroke applicant for the said license. Having heard the learned counsel for the petitioner, despite service none appears on behalf of the state authority. It appears that the matter cannot be disposed of without receiving a report from the state. Accordingly, the state authority is directed to submit a report in the form of affidavit within 4 weeks from date. Reply, if any, by the petitioner within 2 weeks thereafter. Full stop. Hence, the next paragraph. Hence, the state is not appearing. The petitioner is directed to serve the copy of the order, extract copy of the order upon the state authority, upon the state through learned GP. Full stop. Let the matter appear in the monthly list of March. And the same heading, man. It's my the same heading. Deeply. Yes.
Settlement of your ration card from the MRT last belong to the
Okay.
other also. I have passed Miller order.
I understand. Where is the license? No, 21 is a death certificate.
Starting from 20, not 10. And except P1, very 19.
কি দিয়েছেন? অজয় কুমার ঘোষ।
Mine is Ajay Kumar. Page 90 is the license. Page 21 also below the computer. That is the will also kindly consider. Below page 22.
The vacancy notification.
Minor.
Jagadanandapur.
Minor.
My lord, I'm for the state. My lord, we are awaiting the report. My lord, kindly, my lord, adjourn it for the week. My lord, I have asked for the report. My lord, also, my lord, the vacancy notice is at page 22 to 25. My lord, we have asked, my lord, for the clarification, but it is regarding curtailment of, my lord, the number of linked ration cards as a part of the, my lord, rationalization process. Rationalization of, my lord,
Okay.
FPS license. But
No,
kindly,
I
my lord,
understand.
adjourn it for a week, my lord, gives me a week's time.
You know, the order usually asking the usual order to the taking the final decision of the appeal. MAT.
No, it is within the service area.
Yes. So para 6 will not have stated.
So what report you want
My lord, regarding, my lord,
regarding the service area?
regarding the service area, yes, my lord, that is very vital. And also, my lord,
Yes, service area is vital. Whether it is within the service area of that license.
we have asked for the instruction, my lord, it is yet to come. My lord, kindly keeps it any day next week, my lord, I'll apprise your lordship. And I'll be assist your lordship better, my lord.
Very well. Come on Wednesday then. Wednesday.
Next, this Wednesday. Well,
Next Wednesday.
Next Wednesday. I'm grateful. I'm grateful.
Next Wednesday.
I'm grateful.
Thank you. 5th of February. Yes. Yes. Next.
34, 35.
I'm appealing for the state.
You know, lordship kindly consider. Page 90.
License.
License. At bottom of the page floor. 20. The advertisement.
Jagadanandapur. Same location.
At the top of the memo, 415.
415. Yes.
Your Lordship, I have not yet received the instruction from the.
What instruction you require? They are in the same location. License was issued Jagadanandapur and you have vacancy notification is also in respect of Jagadanandapur.
There is no ambiguity.
Yes.
You know, since the appeal is pending, lordship is passing the order, similar order within parliament.
Very. Please take down. Similar direction, David. State is directed to file affidavit in opposition. Within 4 weeks. Reply if within 2 weeks. Considering the facts and circumstances of this case. The state authority has leave to proceed with the selection process, but so far as the issuance of license is concerned, the same shall not be commissioned in favor of any person till the disposal of the batch of appeals pending before the learned division bench of this court being MAT 1543 of 2024. 1543 of 2024. Let the matter go out of the list. What is the mention? Affidavit of service to the applicant. Next.
This is also same. So page 19 and we have page 21.
Where is the license? Bara Chand Ghar. Same location, Bara Chand Ghar.
Phone number 265.
of Krishnanagar.
Yes.
Kaliganj. PS Kaliganj.
Yes, Kaliganj. Block Kaliganj. Yes, Kaliganj.
Similar direction, 4 weeks, 2 weeks till the disposal of the batch of appeals pending before the London Division Bench, being MAT 1543 of 2024. Next.
This is my application. My lord, the subdivisional controller, Islampur Uttar Dinajpur, published a notification on 3rd of June 2024. Lordship, I'm inviting your lordships. Kindly take the notification annexed at page 17 in your lordship's brief.
Yes, got it.
My lord. My lord, if your lordship kindly take from the year, the details of the location of the vacancy. They have given a chart. Beni Kandar, Ilyas Sadvita, Bhelagachi, Jagodgaon, central location near Krishna Mandir, Bijbari. Now they have stated the Mouja and jail number, Belagachi 89, Gram Panchayat Ward, Mathikundra 2. So they have decided by way of this notification, only in Belagachi 89 Mouja, that is the central location according to this advertisement.
Central location is near Krishna Mandir.
Now this is the. I'm grateful, my lord. Now, from the Mouja list of that Islampur area, if your lordship kindly take page 44. They have specified Belagachi 89. Lordship will kindly see the Belagachi 89, Benikandar Sadvita Mouja 90, and Benikandar Mouja 91.
Belagachi 89.
89. And according to this notification, the Mouja and jail number, they have stated 89. My specific case is this, that there is no village, namely Bijbari, within the Mouja 89. And the central location they have stated near Krishna Mandir, Bijbari.
Yes.
Now, the present petitioner before your lordship submitted application online, fees paid, thereafter inspections were carried on. After completion, the inspection stage over. Now they have prepared a chart. Now from the whispering from the office, petitioner came to learn that the person who is from the specifically Mouja 89 can only be the selected candidate. Therefore, the applicants of Mouja 90 and 91, they will be automatically out. But the Bijbari, the village central location Bijbari, there is no such village in a Belagachi 89. So my humble submission, so for the central location point of view, if the notification is arbitrary, then all subsequent events should be declared arbitrary.
No, you are saying that the central location as disclosed in the notification is incorrect.
Is incorrect.
But they have said they want the license for Mouja
89.
Mouja
89
and jail number Belagachi.
Belagachi. But in Belagachi 89, there is no like near Krishna Mandir Bijbari.
No, my only question is how you just start, how you being an applicant,
on the basis
why
of
you take participate?
no, I participated on the basis of that my village is at Beachbody. It is in Mauja number 91.
Then you initially you have to raise objection.
Naturally, now after the inquiry proceedings is going on, and some numbers have been allotted. My number was so much poor, as because on the ground I learned from the office that since you are from the Beachbody, but no such village at Mauja 89 like name Beachbody. This is my only grievance.
So there are no such central location as said to be near Krishna Mandir Beachbody.
This is my instruction
within
on record.
the Belgachi 89.
Yes. This is from the Google, I have searched out the Mauja map. I have never found out. I never found. Now only the state can say some in that regard.
No, where is the village Beachbody?
Malar village Beachbody situated in, Lordship kindly see.
Where is
Malar village Beachbody is Malar situated in Beachbody post Dulali Bita, Thana Islampur, Jela Uttar Deva. Sakin Beachbody is a separate village, and Mauja is the 91. My lord, I have specifically pleaded, if your lordship kindly take my on affidavit, paragraph 5 of my writ petition.
No, whether you have raised any objection till today. Being an applicant, you have applied for the license.
I have already applied.
But now you are challenging the license, the notification.
Because of the fact that if some person is selected on the basis of the central location as advertised in the notification.
That's why you have to raise the challenge before you apply for the license.
Then my lord, kindly send my writ petition and let it be considered as a representation.
You have also not made any representation.
No, I know. I don't know.
So let me see what is your prayer in the writ petition.
Yes. Bandabas, I am praying for cancellation of the notification. Fresh notification for issuance of the fresh notification. And till such, let all the proceedings remain stay. Subsequent proceedings.
Okay. Yes.
Your Lordship, I have instructions that the petitioner is eligible as a dealer, and I will place before your Lordship a sheet. It is a movement sheet which is annexed as Annexure 2. And moreover, the central location is a landmark and it's not to be considered for the selection procedure.
Okay, you take the decision. Please take down. Petitioner is one of the applicant of fair price shop new vacancy notification being memo number 416 stroke SCFS stroke ISP stroke 2023 dated 3rd of June 2024 issued by SCFS Islampur. It is the contention of the petitioner that the central location in the said vacancy notification was mentioned as within invited comma near Krishna Mandir comma Bichbari BICHBARI bracket close. He submits that there are no such central location as mentioned in the notification. It submits that the notification itself liable to be cancelled due to the wrong mentioning of central location. He specifically submits that there are no such central location within Mauja
89.
Central location within Mauja Bhelagachi BHELAGACHI -89 full stop. Learned counsel appearing on behalf of the state authority raised strong objection and submits that the petitioner himself filed an application for getting license. Now he cannot challenge the said. Vacancy notification. Full stop. Having heard the learned counsels for the parties, it appears to me that the writ petitioner never approached the concerned authority in respect of his objections. It appears that the objection raised in the writ petition may be considered by the authority by taking a reasoned decision. Under the above observation, the writ petition is directed, the instant writ petition is disposed of with a direction to the writ petitioner to approach the concerned authority, concerned SCFS Islampur, to submit a copy of writ petition coupled with a copy of this order for taking necessary decision.
Every service.
SCFS Islampur shall consider the writ petition as a representation to the authority, and shall dispose of the same within 6 weeks from date, after giving a reasonable opportunity of being heard to the petition. Full stop. The revision orders shall be communicated to the petitioner within 2 weeks thereafter.
Your Lordship, can it be extended to 8 weeks?
8 weeks. Very well. 8 weeks. Good. ওটা 8 weeks না, ওটা 2 weeks না, আগেরটা 8 weeks, 8 weeks, 6 weeks বলেছি না, ওই আগের লাইনটা দিয়ে বলছি, within 6 weeks. I make it clear that this court has not gone into the merit of this matter, comma, SCFS concern, comma, the SCFS concern is at leave to dispose of the matter according to the law without being influenced by any observation of this court. Full stop. Next para. As affidavits are not exchanged, the allegation made in the writ petition shall be deemed to have been not admitted
My lord, only thing I'm praying,
Affidavit of service filed on behalf of the petitioner is taken on record.
my lord, only thing I'm praying till disposal of such representation for the period of
No,
8
no,
weeks, my
no.
lord, there should,
I
at least
find no merit.
the authority should not proceed with this notification.
No, no.
Lord.
But this is same like earlier matter, page 19 and 20, Lordship kindly consider. Mauja, my lord, is same.
License village.
Village Jaganandapur, Lordship, West Jaganandapur, Mauja, Lordship kindly consider. Jaganandapur, and my lord, page 20, advertisement published, this is also my lord same.
Jagadanandapur.
Right.
Okay, similar direction.
30. 39 had instruction, I think 1 week time. 39. Your Lordship, in this matter, Your Lordship, same identical with item number 34. Instruction is not yet received.
Lordship kindly consider whether it is matched to it or not. There, my lord, we have stated, my lord, it at paragraph 6 within the, my lord, operation area. And my lord, here, my lord, Lordship kindly consider Borochand Ghor Mauja. A license is also. This is
Your Lordship,
there, my lord, wastage of time.
conducting, well, engaged advocate will also engage in another court and requested me to ask for some time because proper instruction is required.
No, Borochand Ghor is the same location. License was issued in respect of Borochand Ghor.
Her name be recorded, my lord.
Just-
Again, we have to come. This is the problem.
Yes. No, no, that is not necessary.
My lord.
Only same location is there. License is also on the
Fine.
same location.
And in other
Different
matter,
location if there, then
Yes,
I can ascertain whether
yes.
it is within the service area of the petitioner or not.
Right.
But it is the same location.
I understand, Your Lordship, but he requested me. That's why
Very
I
well.
submitted.
Let his name be recorded.
Similar direction. Next.
This is almost similar to item number 32. Only difference is, my lord, I could not make any person as a private respondent since nothing is published in the website, I am told.
My lord, as per my instruction, no license has been issued in favor of any candidate, my lord. The inquiry report have been sent to the department for further approval,
What is your
my lord.
prayer? For my appointment, if the process is expedited, that
The process is not yet complete, my lord.
if the process is expedited in that case, my lord. Because my prayer is to appoint me. I have all the eligibility criteria. I have annexed all the documents. I can show my
Let
lord.
them
dispose of the
Yes,
process.
my lord. This is a
How you
premature
appear
delay, my
to this court?
The
Now you have no locus standi. You are being an applicant. Yes. You are the applicant. Let them decide your case. Is there any delay?
But the application, I'll just show the application. This was the notification is of 11th December 2023. And I applied, my lord, page 37. I applied on 15th April
So the selection
2024.
process was yet to be concluded. So why you are here? 29th April, the inspection was done.
The inspection has been done.
Yes,
Page
madam. Inspection
35.
has been done. The inquiry report, inspection reports have been sent to the department, madam.
Let them
The
complete the
concerned
process.
SCFS have.
What is the purpose? Premature.
The only thing, my lord, inspection reports should come to me.
Why? Why?
Yeah, if an inspection is done, I will not even get a report of what has been done.
The selection was not concluded. Why you asking?
হ্যাঁ,
Why you asking? The selection was not concluded.
আমাকে কোথায় রিজেক্ট দেখাচ্ছে? এখানে এখানে নেই।
Pure.
But my instructing advocate on record says that my application has been rejected. May I come back with instructions on another day? I will like kindly make it not today because I don't have the document. I don't have the document with me for which I cannot make this submission before
If
this on.
the whole selection process is not concluded,
How
he
can you
doesn't
say
have
that it was rejected?
I do,
And you have not challenged the rejection.
my advocate on my instructing advocate on advocate.
Did you see the prayer of your writ petition?
My lord,
There
that
is
is
no such challenge of your rejection or otherwise.
that is
Writ petitioner challenge. Writ petitioner.
এটা তো রিজেকশন নেই।
Writ petitioner.
Yes, Mara. His prayer is to appoint the petitioner as the yes,
The writ petitioner approach this court for a direction upon the concerned
I
authority.
will kindly make it not today. May I just ascertain the facts and come back of just not today. My I was
he
humbly
doesn't have any
praying.
locus, my lord.
If you are rejected, then your writ petition would be otherwise.
Supplementary.
So I am disposing of sui apres.
I will kindly make it not
What is
today.
the purpose?
No, not if I can get some paper. So I will kindly humble.
What paper? Show your prayer.
Supplementary.
Show me your prayer. What is the requirement?
Prayers are not there. Well, I will bear
No.
with me for one day, my lord.
No.
না আমাকে রিজেক্ট দেখিয়েছে।
এটাকে কোথায় রিজেক্ট দেখিয়েছে? এটা তো নেই রে বাবা।
আছে রিজেক্ট দেখিয়েছে।
আর রিজেক্ট নেই এটাতে।
বললাম
রিজেক্ট আছে। কে এটা? সাবিরাম।
To disclose the method of selection of process of FPS dealer in connection with vacancy notification number 785/SCFS/DOM 2023 dated 11/12/2023. Full stop. Learned Counsel, next part. Learned Counsel appearing on behalf of the state authority submits that the selection process is yet to be concluded. Considering the submission of the state respondent, it appears to me that the instant writ petition is premature one. Full stop. The right of the present petitioner has not ripened yet. Full stop. Under the above observation, the instant writ petition is disposed of as
But
premature.
the only thing, my lord, my right in respect of selection may not have ripened. But my lord, since the inspection is over, my lord, let a panel be published of the entire.
You do not know the law, I think. They are not bound to disclose the selection process or the result of the inspection. They are in law not bound. They have to place it before the authority. Not you, not anyone. Not to the court also. Disposed of. Affidavit service as premature one. Affidavit service file on the petition taken on record. Disposed of.
This is a similar matter, but out here selection process is concluded. In fact, there are two successful persons who have made them private respondents as well.
So in this case, selection has been made.
Yes. In favor of the private respondents. Respondent number 7 and 8.
Respondent number 7 and 8.
8, my lord. Selection has been.
2 persons were selected.
How
2 persons were selected?
They probably make up firm or firm that probably are part of a partnership firm, that is right.
Okay, partnership firm. Have you served upon the private respondents?
My lord. The private respondent. No, the private respondent I have served, but it has not yet reached. I just looked into the.
Can you come and serve and come? Okay. Not this week.
The affidavit of service may be taken on record.
Come with that. After service, you come with the fresh affidavit of service.
May I be permitted, Lordship? I beg to appear on behalf of the petitioner, Lordship. This writ petition is pertaining to the selection process of new licensee, Lordship. That in the area service area of the petitioner, new vacancy notification has been issued, Lordship, and the same
is
has
the
been
license?
challenged. Lordship, that will transfer from the page number 39, Lordship. That the petitioner is the license holder of the locality, Lordship, and subsequently, Lordship, one notification has been issued, that is in page number 41, Lordship. And the petition is paying for the stay of the notification, Lordship, and similar case has been taken place, Lordship, has hold the same, Lordship, as the matter was earlier taken up in the similar issues, Lordship, and then after, Lordship, that one judgment has been passed, and then after that has been referred to the division bench, and your Lordship was holding the same view, Lordship, that until and until that
Is
branch
it
of
within
the,
your service
yes,
area?
your Lordship, it is in my within my service. The state is the here, Lordship, state is in better position to reply on that particular answer, Lordship.
Is it within the service area of the petitioner?
Your Lordship, we have not received the exact instruction yet, Your Lordship. This is the difficulty.
Lordship, kindly come to page number 39, Lordship. That the petitioner is the having the lawful possession go down space as village post Kalitola Dayar.
Yes, Kalitola Dayar.
PS
And the
Baharampur,
notification?
MS Godown. Yes, and what is the notification is, Lordship, also in Kalitola Dayar, Lordship, that the post office is Kalitola Dayar, GP is Harisamadi, Baharampur.
No. Mauja is otherwise.
Lordship,
Fateh Singh there.
Mauja is, Lordship, Fateh Singh Diyar, and in my case, Lordship, my Mauja is Fateh Singh Diyar, Lordship. Kindly come to page number 39, Lordship, will find. In point number 1, Lordship, that for that mentioned there, Lordship, Mauja, Fateh Singh Dayar, Lordship, in page number 39, Lordship. In my license, Lordship, it has been mentioned. That he started from having lawful possession of the godown space at, Lordship has find.
Yes.
That village post Kalitola Dayar, police station, Baharampur, MSD such and such, godown, second godown is such and such within Mauja, Fateh Singh Dayar, Lordship. Have Lordship have find?
Yes.
And kindly come to the turn to the page number 41, Lordship.
Okay.
And the same Mauja, Lordship, is there also. Lordship will find from that the envelope containing the application submitted through registered post, speed post, or by hand should be subscribed application for engagement of FPS dealer at village.
Where is the affidavit of service?
Lordship. May I hand over the suggested order, Lordship, in earlier occasion, Lordship have passed the order, Lordship. That during pendency of the branch of MAT application, Lordship, they should not be granted with the license, Lordship. They can proceed with the with their notification, but not to reach the finality, Lordship.
State is directed to file affidavit in opposition within 4 weeks from date. Reply, if any, within 2 weeks thereafter. Next, having heard the learned counsel for the party and considering the materials on record, the state is at leave to proceed with the selection process of the impugned vacancy notification. Selection process. Same. But so far as the license is concerned, issuance. similar direction. MAT 1543 of 2009.
They have to file a report with the forward affidavit and subsequent. Get to do.
Madam, for the petition. But matter relates to my appointment of APS dealership. The petitioner earlier came before this honorable court, and your lordship was pleased to pass order page 14 and 15, my lord. And pursuant to your lordship's direction, advertisement was made.
Yes.
Pursuant to your lordship's direction, my lord, notification was issued page 9. 5th December 2024.
Yes.
But your lordship was pleased to direct to publish notification dated 25th June 2024. That I have annexed page 26. But now what they have done, they have imposed an age bar to debar the petitioner for participating in the selection process. But in the 25th notification, 25th 6/24 notification, there is no age bar. And now the mode of application is only online. Well, I am not issued, but earlier it was registered post and online. Both were there.
So what is your difficulty?
Without age bar, they are debarring their petitioner, my lord. They are violating your lordship's order.
How would they violate?
Without following the notification dated 25th June 2024, they have issued notification imposing an age bar.
Where is that age bar?
Age bar, my lord, kindly sees. Page 10, eligibility criteria, my lord, 2, Roman 2, my lord. The individual applicant or partners in the partnership form must be above 21 years of age and below 45 years of age on the date of birth. But earlier notification, but that was not imposed. And they have issued notification without following your lordship's order.
No. In the earlier notification,
Yeah, page 26. No age bar was.
They were to declare the notification in virtue of the West Bengal Public Distribution System Maintenance and Control Order 2013. But now they have declared the notification by virtue of West Bengal Targeted Public Distribution System Maintenance and Control Order 2024. That is a separate notification.
Separate notification, but your lordship was pleased to direct to publish notification as per the notification dated 25th June 2024. But vacancy ID is same.
New law is there. They have to.
But vacancy was declared 2022. But vacancy ID is same. Your lordship is kindly have a look. Vacancy ID. But 25th notification vacancy ID and 5th December 2024 vacancy ID is same.
Vacancy ID may be the same. That is the location same.
And 2022 vacancy was declared. The authority did not fill up the vacancy. To debar the petitioner, now the age bar was imposed.
Not to debar the petitioner, all the persons above the age 45 years.
And your lordship directed to follow the notification of 25th June 2020.
No. So what is your prayer now?
Now to cancel the notification and publish.
They have issued the notification by virtue of the Targeted Public Distribution System 24.
Yes.
Then how can I debar them? New law is enforced. They have to.
Your lordship was pleased to direct to notification dated 25th June 2024. Your lordship is specifically stated, page 14, 15. Only to debar the petitioner, my lord, these are.
I find no justification. I have directed them to issue the notification in terms of advertised notification dated 25th of January
Yes.
2024.
25th January, that is incorrect. 25th June, notification is 25th June 2024. Page 26. I have annexed the notification. Page 20. Vacancy was declared 2022.
No.
But cancellation, every time they have cancelled, each notification in cancellation of the earlier notification. They have issued 4 notifications in cancellation of earlier notification.
New law is there introduced.
But
They
they
have
did
to
not-
follow the law.
Yes, but my lord was pleased to direct to follow the
Yes,
notification.
I have directed them to issue.
Yes, 25th June.
Very well. Let them answer it.
Yes, right.
Having heard the learned counsel for the petitioner, it appears that the matter cannot be decided without giving opportunity of the state to file a report. Let the report be filed within 4 weeks from date. Reply if any by the petitioner within 2 weeks thereafter. Full stop. Next para. Despite service none appears on behalf of the state authority.
Yes, I
You appear.
yes.
Okay. Now cut. Despite service cut. Let the matter appear in the list. Will appear in the monthly list of March.
But interim order,
No. Next.
I am for the state.
The vacancy for February shall have been notified. You should kindly turn to page 18. This is my affidavit of sign. It's 1A.
Yes.
You should kindly turn to page 22. This is the vacancy page 18. Kindly turn the page 19. One condition I shall place to your lordship. That is part 2, 8, clause Roman 7 at page 19. Financial capability. Roman 7. Working capital. Have you lordship got that?
Yes.
Working capital or fund required at the time of application. Applicants for dealership must have a bank balance of rupees 50,000. Kindly take note of bank balance of rupees 50,000. Only in the form of savings account, current account, or fixed term. Fixed deposit in a scheduled commercial bank or post office as working capital on the date of application. Only condition you have to show bank account that there are 50,000. Now, your lordship, kindly come to page 23. Now, this is the newspaper publication. Your lordship will get it from serial number 3. Serial number 3. Subdivision Dome Call, Block, Raninagar 2. Have you lordship got my lord? Fourth column. Subdivision Dome Call, Block, Raninagar 2.
Raninagar 2. Yes.
Serial number 7 is the subject vacancy notified.
Serial number 7. Memo number 246.
Yes. The pursuant to such vacancy notice, within time I have applied for page 23. On 7th of September 2024, I submitted my application. Date is very important, my lord. 7th September 2024, I have submitted my application, page 23.
Yes.
Now, your lordship, kindly, next page. The duly filled in prescribed application, all documents I have annexed. It will appear from the following pages. Type, copy, then kindly turn to my lord, page 32. I am running my business. I shall run my business from the shop of godown of my father. So NOC has been given in the form of ABDB that has been given. Kindly turn to page 36 with the also document. Need not go through the same. It's page 36. It's a sketch map of my godown at page 36. Now, your lordship, kindly turn to page 39. The bank account. I have shown to your lordship, I have submitted my application on 7th of September. The page 39, kindly see the last column says 6 September 2024 in my name. Kindly see the name of the account holder, Mr. Jamatul Biplab Jannatul Biplab Dora. That's the petitioner before Lordship, 6 September, 55,000. At bottom. 6 September, bottom, left hand side, then 55,000.
Yes.
Admittedly, my lord, on 7th September, this money was not there. Due to the serious illness of my father, I withdrawn some money from that account, which will appear from the next page. On 7th September, when I submitted my application, this money was not there in this account. But there is another account, if you want to kindly see, that we have also placed, that will appear from page my lord 50. Kindly turn up. This is a joint account with my brother, Ojafia, Imanu, Yamin, and petitioner before Lordship, page 50. State Bank of India joint account, holder by my child and his brother. Ujafia, Ipanul, Imamin, and Janatul Biplab Torba, that is the petitioner before Lordship, joint account. Kindly see, my lord, 4th September, 5th September, all board rupees 1,69,000, 3,20,000. Then next page, kindly see. 1st November, or continuing. More than my lord, 1,50,000 in all together. So requirement is my lord 50,000.
Okay.
Then my lord, page 52 is the intimation to my client that the inquiry will be conducted on 20th December 2024. Inquiry has been conducted. Report has been submitted. I went to the subdivisional control office. He says, since your second account, your name is the second position, this account will not be considered. You should kindly turn up 2-3 paragraph of my petition. Paragraph 4 onwards, page 3. Paragraph 4, page 3. I have made out the case. I'm reading from paragraph 4 at page 3. The petitioner states that being the most eligible and most suitable candidate and having all eligibility criteria as per vacancy transfer, including short-term go down and financial solvency, your petitioner submitted his application in prescribed application form C. Against the said vacancy notification dated 15th May 2024 and along with the said duly filled in the prescribed application, your petitioner also deposited the application fee and also submitted all other necessary documents. Did not go through the same. Kindly turn the last part one paragraph. It is pertinent to mention here that SBI savings account of your petitioner is a joint account along with the elder brother of your petitioner, and in terms of vacancy notification date transfer, there is no bar to hold a joint account by an applicant. Intend the money, then the required money as working capital pursuant to the vacancy notification date transfer in both the bank account. However, due to medical emergency of father of your petitioner compelled to withdraw some amount of money from the one bank account, that is IDFC bank account, just before 1 day of submission of the duly filled in application, prescribed application, xerox copy of the document. Then paragraph 7. Your petitioner states that during course of inquiry, your petitioner submitted all the required documents, including sketch map of short-term go down and the bank account details of both the bank accounts. However, after taking note of both the bank account details, the inquiring personnel expressed their satisfaction to also. Your petitioner further states that after conducting the inquiring personnel directed your petitioner to put his signature in the blank paper. That needs to kindly come to the next page, page 8, paragraph 8. Your petitioner states that after conducting such inquiry, the inquiring personnel directed your petitioner to submit both the bank account detail before the subscription controller return supply room call. Accordingly, your petitioner time and agent visited the office of the subscription controller room call and submitted both the bank account. Paragraph 9. Your petitioner states that when your petitioner was waiting for the personal interview or personal hearing, all on a sudden, with an utter shock and surprise, subscription controller room call verbally intimated your petitioner that the application of your petitioner could not be recommended before the higher authority. Accordingly, your petitioner visited the office of the subdivisional controller and came to learn that the subdivisional controller is going to reject the application of your petitioner, since in the joint bank account of your petitioner, the name of your petitioner has been reflected as second account holder. Well, I fail to understand why these reasons. There is no stipulation in any controller or any notification.
No, this is only verbal intimation.
All right. So let my management take instruction.
And I have to take
file a
instruction.
report.
Yes.
I'll file my report for my affidavit.
But means they are going to earlier. I'm not paying for any injunction.
Very well.
It will be better to deal with these paragraphs. So affidavit will be better. Otherwise, if they don't.
Yes, you have mentioned in the affidavit. So affidavit is report in the form of affidavit. Please take down. Petitioner applied for FPS license in terms of memo number 246 stroke SCFS stroke DOM 2024 dated 15th of May 2024 issued by SCFS DOM call. Full stop. It is the case of the petitioner that he has complied with all the formalities according to the said notification, and he is most eligible candidate to be selected as successful selected as a license holder. Selected as a license holder. Full stop. During the said procedure, he has been informed by the concerned SCFS verbally that his candidature may be rejected due to not maintenance of requisite bank account, requisite balance in the requisite working capital in his bank account at the day of filing application. Full stop. He submits that the petitioner has furnished two bank accounts at the time of application. Full stop. One bank account was standing in the name of himself. One bank account is joint bank account. One bank account is joint bank account, comma, standing in the name of petitioner and his brother, having sufficient working capital. It is the case of the petitioner that since it is a joint account, the concerned SCFS may, concerned SCFS may reject his application. Reject his application. Full stop. On such apprehension, the instant writ petition was filed. It appears that the instant writ petition cannot be disposed of without giving an opportunity to the petitioner, without giving an opportunity to the state respondent to submit a report on the form of affidavit in respect of allegation made in the writ petition by the petitioner. Full stop. In respect of the allegation made by the writ petitioner in the instant writ petition. Full stop. Considering the submission, let the report be filed. Let the report in the form of affidavit be filed within 2 weeks. Within 2 weeks. Reply, if any, within 1 week thereafter. Full stop. Let the matter appear in the list 24th of February. Another same heading.
24th February, ma'am.
24th of February, another same heading. Give me the affidavit of service.
Affidavit of service দেওয়া হয়েছে।
Affidavit of service filed on behalf of the petitioner is taken on record. Next.
24 তারিখ
That's it.
In this matter, I appearing for the petitioner.
Take the mic.
My lord, in this matter, I appearing for the petitioner, my lord. My lord, I pray not today, my lord.
Not today. Come on next week. It's not this week.
Great.
Is there any report? Next. Not this week.
No, I'm for the petitioner, madam.
Mr. Omtolal Chatterjee is appearing on behalf of the state. I am
Yes.
praying not today on his behalf because just now he has intimated me to give an adjournment on his.
What is the matter?
The restoration application, my lord. It was dismissed on default, my lord, on 6th of August 2024. Thereafter, my lord,
How many days delay?
a delay for about 74 days. Now, what happened, my lords? After the dismissal for default, my lord, the matter again listed for to be mentioned for correction. It was uploaded in the wrong WPA number. This is for default order. Still now, my lord, the order is not uploaded in my petition, my lord. Therefore, it was delay, my lord.
What is the difficulty? I cannot understand your submission. Can 1 and can 2.
Can 2, ma'am.
Can 1 is for restoration.
Restoration application.
Can 2 is for condonation of delay.
Condonation of delay, ma'am. Kindly see the page 9, my lord.
So what is your name? Petitioner's name?
Mausumi Maiti.
Yes, your case, your writ petition was dismissed for default.
On 6th August 2024.
Yes.
But wrongly it was typed as 25426.
Yes.
It was again come on hearing on 19th August 2024.
Yes.
Where I was appearing, my lord.
Yes.
But my lord, the still, my lord, the order passed in 25828, dated, my lord, 6th August 2024 was not uploaded.
It was uploaded. It was server.
In this writ petition, it was not uploaded. In 25828, it was not uploaded. Therefore, it is a delay my filing the application.
Masul? Server is it? 25828 of 2023 to server.
It was not still date, it was not uploaded in website, man. It was uploaded in WP number 25426, which is wrongly typed as WPA number.
No. It was uploaded in 25828. This is the order copy of server.
Two five eight two 25828.
So whatever may be, what is your prayer?
And for restoration and condonation for 75 days, 74 days, my lord.
What is the writ petition about?
My writ petition about, my lord, challenging the appointment of the private respondent. But I'm not ready, my writ petition.
Your Lordship, kindly make it not today.
Let it be restored, my lord. Thereafter, my lord, it to be.
Exceeded to be
There was a
petitioned
direction
tomorrow.
to file a report by the state, my lord, in the immediate petition.
As per my instruction, Mr. Chatterjee is not here. For this reason, he.
Very well. Come on tomorrow. Not today. Come on.
Great.
Next. Contempt applications. Yes, who is appearing this matter? Petitioner? Okay, call. Next matter. Not today.
Ipti, my lord, in behalf of state, my lord, Ujani Pal Samanto, he's not come to the court, my lord. I'm praying for not today.
You are for the
I'm for the state, my lord.
state.
I am for the university and we have complied the order, lordship.
Complied the order.
Yes, lordship. As per your lordship direction.
Who is for the petitioner?
Petitioner is not.
Give me the file.
We have handed over all the documents to the Director of Technical Education, lordship.
Okay, Mr. Mukhopadhyay is there.
Yes, lordship. Lordship, we take this matter day after tomorrow. Stated.
Mr. Mukhopadhyay has informed me in the course of hearing of other matters that the matter this matter may be disposed of as the matter has been complied.
Complied. Since petitioner and
Yes, you are for the
State, my lord, but I'm
public
this
instruction.
matter- No, my lord, I'm state learned senior, my lord. She has not come to the court, my lord. Ujani Pal Samanto. I'm not engaged in this matter, my lord.
Who leading you?
Just over telephone, she told me, my lord.
Mr. Ganguly
He
is
is
there.
ill, my lord. Hey, yes, my lord.
Mr. Ganguly
Yes,
is
my
there.
lord. Yes, he is engaged in code number 35.
Very well. Not this week.
Okay. Lordship, kindly record an order, lordship.
None appears on behalf of the petitioner. Let the matter be adjourned today. No, the state as well as the university is represented through their learned council. Stop. Let the matter appear in the list in the next week. Next. No one is appearing. Next. Not today. Not today.
My lord, 53, my lord, in this matter, my lord, the contempt application filed by me, last occasion, my lord, state has taken time, since they are, my lord, saying that they are preferring an appeal. My lord, last occasion, they are saying, your lordship, give them 2 weeks time in, my lord, the December, probably, my lord, in the December, but come in the list, but thereafter, they have no, the matter has not been listed, no stay order, nothing else. And in this way, they are flouting the order of this honorable court.
My lord, I am praying for
Or long before the order has been passed, let there be a direction for personal appeals of the Director of Public Business. Otherwise, this matter cannot be heard out. Your lordship, kindly, last occasion also, they have taken time for the
This is of Subroto Notto.
Yes, my lord.
There are two matters of
Yes, my lord. Devotos not and Subroto. One is filing the contempt application, other is still, my lord, not filing, but the contempt letter has been issued.
whether they have preferred any appeal.
No. The state has been preferred appeal.
State have preferred appeal.
Yes, my lord. State preferred appeal since they are not prosecuting with the appeal. They are simply sit or file an appeal, and my lord, on this ground, my lord, they are taking time. And my lord, in this occasion, my lord, I am saying, my lord, only with preferring the appeal, it doesn't mean that your lordship will not proceed with this contempt application. There is several Supreme Court judgment, and my lord, once Mr. Ganguly is not appearing, neither Mr. Pal is appearing. All of them, my lord, only
Yes,
taking
what
this
is your submission?
No, my lord, I am praying for only not today.
Lord, I am
My
not
lord,
today.
Same. Yes, my lord, I am praying.
My lord, let this matter be come up tomorrow at 2 p.m. to be mentioned.
Tomorrow, I
To
shall
be
take
mentioned.
up the contempt matters first.
Okay. To be mentioned, my lord.
No, contempt matter will take up first. So your matter will come first.
Okay.
Okay. Contempt matter will listed first. Applications আছে contempt আছে প্রথমে contempt দেবেন তারপর application তারপর দেবেন new motion. Okay.
Your Lordship,
Only not today.
next matter, item number 54, contempt application and the main writ petition, both are already infructuous, Your Lordship.
They have already complied with.
Your Lordship, some order has been passed by the Honorable Division Bench, so the contempt.
Okay. Please take down. Learned counsel for the petitioner submits that by virtue of the decision of the Honorable Division Bench in this matter, both the applications, both the writ petition as well as the application are become infructuous. Considering the next paragraph, considering the submission, the contempt application being CPAN number 1742 of 2024 is disposed of as infructuous. Next rule, if any, rule, if any, issued by this court is hereby recalled.
Your Lordship, along with the writ petition, contempt application as well as the writ petition.
Writ petitions, both. Being CP, কি বলে? না তার আগে consider submission, content application being CPN along with the writ petitions being number WPA 26477 of 2024. Be disposed of as as infructuous.